Senate Economics Legislation Committee for the inquiry into the Corporate Collective Investment Vehicle Framework and Other Measures Bill 2021. On 2 December 2021, the Senate referred the matter of the Corporate Collective Investment Vehicle Framework and Other Measures Bill 2021 to the Economics Legislation Committee for inquiry and report by 3 February 2022. The committee has received 18 submissions so far, which are available on the committee's website. As this is a public hearing and a Hansard transcript of the proceedings is being made, although the committee may determine or agree to a request to have evidence heard in camera. Information on procedural rules governing public hearings and claims of public interest immunity has been provided to witnesses and is available from the Secretariat. Any witness called to answer a question for the first time should state their full name and the capacity in which they appear. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I remind any media representatives listening to follow the media guidelines and any instructions of the committee secretariat. I ask everyone to ensure they have their mobile phones switched off or turned to silent, which I will now do. I would also like to advise witnesses that answers to any questions or notice should be sent to the secretariat by close of business Tuesday, 25 January 2022. And I note that's an aggressive timetable, so if there are questions on notice, I really do appreciate on behalf of the committee accommodating that timeline. I now welcome representatives from the Australian Securities and Investments Commission. Thank you for appearing before the committee today. I remind officials that the Senate has resolved that an officer of a department of the Commonwealth or of a state or territory shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into microphones and please ensure your microphones are set to mute when you are not speaking. As I've said, questions on notice should be sent to the Secretariat by close of business Tuesday, 25 January 2022. I invite our witnesses from ASIC, if they like, to make a brief opening statement should they wish to do so. And for the Hansard record, could you please each state your name and the capacity in which you appear?
Thank you very much and good morning, everybody. My name is Kate Matt of Investment Managers team. I'm appearing here today with my colleague Jane Eccleston, who is the Senior Executive Leader of our superannuation team. If it is all right, I would like to make a very short opening statement before handing over to my colleague Jane Eccleston.
Yes,
so
please.
Thank you.
Yep.
Thank you. And thank you very much for the opportunity to appear before you today to discuss the Corporate Collective Investment Vehicle Framework and Other Measures Bill 2021. So the corporate collective investment vehicles share the characteristics of other internationally recognised investment structures. We understand the new regime is intended to increase the international competitiveness of Australia's managed fund industry. ASIC supports the new regime and is committed to its implementation. We are committed to ensuring that CSIVs can begin operating from the 1st of July 2022 when the regime is due to commence. I will focus my opening comments on how ASIC is preparing for the implementation of the new regime. An important focus for ASIC has been to ensure that the new regime works effectively within the existing licensing and regulatory framework established by the Corporations Act. The bill is complex and intersects with multiple areas of the Corporations Act, including securities, corporate governance, insolvency, and financial reporting. Multiple teams at ASIC have provided technical input to assist Treasury with many aspects of the bill. ASIC will continue to support Treasury as it develops primary law and regulations for the CSIB regime. On the 1st of July 2022, ASIC will be ready to license corporate directors, register CSIBs and relevant sub-funds, and provide a publicly available register of CSIBs. We are on track to ensure a build for these functions is live upon commencement of the new regime. ASIC will also publish relevant regulatory guides before the 1st of July to ensure that corporate directors understand their obligations and duties under their regime and can become appropriately licensed and operationally competent. ASIC plans to publicly consult on these regulatory guides before they are published. We look forward to continuing our work on implementing the new regime. I will now pass to Jane Eccleston to provide some brief comments on the superannuation aspects of the bill.
Thank you, Ms. Metz. And if I can just place on the record our thanks to everyone at ASIC who's been involved in terms of the establishing the regime, the providing advice. It's been a big task, and I think that should be recognised because I think it's an important reform. So over to you. Thank you. Over to you, Ms. Eccleston.
Thanks very much. Good morning, everyone. So as mentioned by my colleague, Kate Metz, my name is Jane Eccleston, and I'm the Senior Executive Leader of Superannuation at ASIC. So I propose to now make a few opening remarks about the Retirement Income Covenant and how ASIC plans to approach the implementation of the covenant. So ASIC supports the introduction of the Retirement Income Covenant, which is Schedule 9 of the bill, and it inserts into the Superannuation Industry Supervision Act a new covenant in Section 52. The new covenant requires superannuation trustees to formulate, review regularly, and give effect to a retirement income strategy for beneficiaries who are approaching or who are in retirement. It's a principles-based requirement that gives trustees flexibility in how they go about assisting their members. So the Retirement Income Covenant is designed to sharpen superannuation trustees' focus on the retirement phase, and in particular, how they help their members to convert superannuation balances into retirement income. ASIC expects the covenant will lead to improved outcomes for retirees and greater consumer confidence in the superannuation system. So both ASIC and APRA have a role in monitoring and enforcing the Retirement Income Covenant. ASIC's already thinking about how we can facilitate the effective implementation of the Retirement Income Covenant once it's passed into law. We've been in close discussions with APRA about implementation and the way in which regulators can communicate expectations relating to the covenant to industry. At this stage, ASIC's not intending to issue specific regulatory guidance on the new covenant. However, we will be communicating to industry about our expectations ahead of the covenant taking effect. Our focus in these communications will be mainly on assisting trustees in providing information and tools to their members as part of their retirement income strategies. In implementing the covenant, trustees will need to be mindful of their existing obligations under the Corporations Act, for instance, and also the SIS Act. For instance, as noted in the explanatory memorandum to the bill, trustees can fulfil the requirements of the covenant and create effective retirement income strategies without providing financial advice or without breaching the anti-hawking rules. I appreciate that industry has raised a number of questions during Treasury's consultation process about the financial advice framework, in particular, how it may impede trustees in developing and implementing their retirement income strategies. But a lot of the issues here are policy issues and therefore a matter for government and parliament to consider. And I note that the draft terms of reference of the review of the quality of financial advice review state that the review is to examine the regulatory framework for financial advice and have regard to the Retirement Income Covenant, among other matters. So ASIC will support and engage with this review. In terms of what APRA is doing in relation to the Retirement Income Covenant, I understand they've made a submission to this committee, and ASIC supports the approach to implementation APRA has set out in its submission. ASIC has been working closely and will continue to work closely with Treasury in the development and implementation of the covenant. So I'm happy to answer any questions you may have in relation to the Retirement Income Covenant, and I'm sure that Kate, my colleague Kate Metz, will be happy to answer any questions relating to the CCIV components of the bill. Thank you.
Okay, thank you very much, Ms Eccleston. I might just ask first, Senator Chisholm, do you have any questions for these witnesses?
Yeah, I do.
Okay, over to you.
Thanks. I'll just start on I've got questions on both the CCIV and the Retirement Income Covenants, but I'll start with the CCIV first. Can you just provide a bit more detail in outlining what ASIC's role will be in the administration of the CCIV framework?
Certainly, I'm happy to do that. So ASIC from day one will need to be in a position to register CCIVs and sub-funds. We'll need to license corporate directors. We will need to register sub-funds. We will maintain a public record of registered CCIVs and sub-funds. We will assess any applications for exemptions and modifications and provide any relief as necessary and appropriate. And we will administer and enforce the new CCIV laws. So in relation to CCIVs, we do have a broad suite of regulatory tools that we can use in the event that we see any issues or concerns.
Okay. And how will this differ from ASIC's existing relationship with Australian fund managers using the existing managed investment trust or scheme frameworks?
So the structure is obviously different. So it's a corporate structure as opposed to a trust structure, but many of the issues remain the same and many of our regulatory tools remain the same too. So under both structures, there will still be a requirement to be licensed. There will still be a requirement to issue product disclosure statements, and aspects of the law like DDO and the product intervention power will exist to both structures.
And how will you ensure regulatory parity between existing Australian managed investment frameworks and CCIVs?
So that might be a question best to Treasury, given that it goes to the settings as set out in the Act. But, you know, we are neutral as to structure.
Okay. So ASIC will be charged with managing the registration of CCIVs. How will this responsibility fit into the Modernising Business Registers program?
So ASIC has been working closely with the ATO and with Treasury on this issue. Question is perhaps best directed to the ATO, but there's certainly been a lot of ongoing work between the agencies to ensure that it does work smoothly and that registration can occur in a sensible way for industry.
Okay. Just moving on to the retirement income covenants. So when giving effect to their retirement income strategies, superannuation funds may provide financial advice to their members. We saw significant failures by retail superannuation funds in relation to financial advice through the Banking Royal Commission. How confident is ASIC in the continued good behaviour of retail super funds in relation to the provision of financial advice?
So I think one of the things that's stressed in the explanatory memorandum and certainly in the communication messages that we've been having with industry to date is that the Retirement Income Covenant is not an excuse not to comply with the other aspects of the law. So that's something that we've certainly made quite a bit of in relation to our communication messages about the covenant itself, but more broadly in relation to financial advice. You may recall that last year in February, for instance, there was a High Court decision which was about the difference between personal and general advice and whether it was appropriate to use general advice. So I suppose what I'm really trying to say in a roundabout way is that it is an area that we are quite focused on, and will continue to be aware of some of the potential consumer detriment when financial advice is not delivered in an appropriate way.
Will ASIC be considering any additional guidance in relation to the provision of advice by superannuation funds?
So as I mentioned in my opening statement, we're not proposing to amend our formal regulatory guidance, and indeed, the quality of advice review, does put into question, what the settings may be in the future. So it's not a good time to sort of amend that guidance. Obviously, we do have discussions with industry from time to time, and there is communications. The retirement income covenant and how it applies, given the current settings in the law, may come up through those communications. But it's not something that we have in our back pocket, some sort of formal communication that we intend to make at this point in time.
Okay. Thanks, Chair.
Thank you, Senator Chisholm. Ms. Eccleston, I might, if I can, just before I pass on to Senator Bragg, I might just follow up that question from Senator Chisholm, just in relation to the issues of anti-hawking and also provision of financial advice in the context of the retirement income covenant. So I'm just going to put to you some comments which have been made by Industry Super Australia in this context. So obviously, I suspect you're aware of this because you've broached the subject before I could specifically refer to this. So, but I think it is important we flush this out a bit for the purposes of this inquiry. So just in relation to the anti-hawking prohibition, on page 7 of Industry Super Australia's submission, I quote from them, they say, the anti-hawking reforms which commenced in October 2021 are designed to protect consumers from unsolicited offers of financial products. The reforms contain an exemption from anti-hawking provisions for account-based pensions. ISA understands that, consistent with the government's efforts to increase take-up of retirement income products, the exemption from the anti-hawking prohibition for offers made by or on behalf of superannuation trustees relating to a member's move to the retirement phase was intended to include retirement income products offered by a fund to its members. However, we are concerned that the Corporations Regulations 2001 may not achieve this result. This is because the exemption relies on Regulation 7.1.04E, which relates only to account-based pensions. Applying the anti-hawking prohibition on retirement income products that are not account-based pensions will hamper funds' ability to offer retirement income products to members. There should be a clear exclusion that readily enables trustees to offer and promote retirement income products that they believe are in the best financial interests of members. End quote. Could I get a response from you, if Ms. Eccleston, just in relation to that issue which has been raised by Industry Super Australia, please?
Sure. So to some extent, this is a policy decision about what the carve-out should be from anti-hawking. But I think it's probably useful to note that the retirement income covenant is a really flexible type covenant. Like, it's designed to make sure that trustees have a strategy and then implement that strategy. So it's not straitjacketing them in terms of what they do. It's really about them coming up with a good approach to assist their members. So it's not forcing them to offer products in a way which might breach the anti-hawking provisions. The other point I wanted to make was that the anti-hawking provisions are really designed to stop people making a decision when they're under pressure in a real-time interaction. So that's the sort of nub of those anti-hawking provisions prohibition. There are other ways that you can bring to people's attention products without breaching the anti-hawking provisions. So, for instance, you can communicate with them about the product in a way which isn't a sort of real-time interaction by doing a mail out. You can give them information rather than an offer or invitation in some sort of real-time setting. And you can also get their consent to be approached to have this discussion in a real-time communication. To the extent that there's a perception that there may be some sort of fatal inability for trustees to really provide to their members information or opportunities to take up retirement products other than account-based pensions, I think that's not really the case.
Okay. And just one other question I wanted to put to you. Again, it's from the Industry Super Australia submission, and that's in relation to what's referred to as intra-fund advice. And if I can quote from their submission, page 5, the law prescribes types of advice that cannot be collectively charged. ASIC has given guidance on the types of ongoing advice for which a superannuation trustee is likely to be allowed to collectively charge. The topics are narrow and do not take account of a member's wider financial and household situation or access to Centrelink payments. Expanding intra-fund advice to include advice to members about retirement income strategies that take into account age pension eligibility, other Centrelink payments, non-super assets and non-super income, and which include the member's household, would be an efficient and cost-effective way for members to receive trusted advice on retirement income strategies. ASIC adopted a similar approach in its COVID-19 measures to allow intra-fund advice on early release of super to extend to a member's household, end quote. Do you have a response to that, Ms. Eccleston, those concerns? And I note that some of these might go into policy areas. But
yeah, I think they really do go into policy areas. To the extent that the ISA make the point that intra-fund advice is limited in scope, that's absolutely true. I suspect that the Quality of Advice Review is going to get a number of submissions about whether expanding intra-fund advice is an appropriate decision to make.
Okay, thank you. Thank you very much. Senator Bragg.
Thanks very much, Chair. I just had a couple of questions on the CCIV, so I think those are questions to you, Ms. Metz. So the way it works is that the managers will have to come to ASIC to get the scheme registered. Is that right?
So the scheme will need to be registered. That's correct.
Okay. And so does it need to be a registered scheme before it can be a CCIV, or does that happen it's part of the same process?
So I mean, it will happen reasonably concurrently.
Okay.
So there's a licensing process and a registration process.
Okay. And so is it so who actually comes to ASIC? Is it the responsible entity or is it the scheme operator?
So CSIFs don't have a responsible entity as such. They have a corporate director.
Okay, corporate director. So the corporate director comes to ASIC?
Correct.
Okay. And okay, so in a practical sense, if I'm a fund manager, so that means I have to run a responsible entity structure as well as a corporate trustee, effectively.
If you are offering both a managed investment scheme and a CSIF.
Yeah, okay. Okay, so so even though they could be investing in the same underlying assets, they are structurally quite separate.
So the two, yes, I mean, you will be able to pick what structure you use, whether you use a traditional managed investment scheme structure, which is a trust-based structure, or whether you use a CSIF.
Yeah, and have you done much engagement with industry on on this?
Look, we have had a number of discussions with industry participants, and I know that Treasury has as well. I think that, and you will have seen from the submissions, I think that people are generally interested in the CCIV regime and are looking at participating in it. I think timing will be an issue for them. I think it's obviously been a very sort of busy 2-year period, and there are lots of things that fund managers are currently engaging in. And there are also some issues which have been raised around taxation and transitioning across from a managed investment structure to a CCIV structure. But in terms of those, I think the ATO and Treasury will be best placed to help you better understand those issues.
Okay. How many registered MISs have you got at the moment?
So at the moment, there are around 425 registered MISs.
Okay. And how many?
And they operate 3,616 schemes. So I think those numbers were from December, January.
How many?
So there are currently 3,616 registered schemes.
3,600 schemes. And how many REs?
There are 425 REs.
400 REs. Okay, it's quite a lot. So 400 REs and 3,000 schemes, 6,000 schemes. Okay. And do you think many of the schemes will transition to become CCIVs?
I think over time, I'm sure some will, but I can't say with any degree of certainty when that will happen and how many will look to transition across. And I think, and Treasury can talk to this, I think some more work needs to be done on those transitional aspects in order to facilitate movement across.
Okay. And do you have a public register for the 3,600 schemes?
There is a register.
Okay, that's all. That's all. I was just wondering if you had that up and running. So there'll be a public register for the CCIVs, and there'll be a public register. There is already a public register for the registered scheme.
So there will be a register. Sorry, I should clarify. There will be a register for the schemes. Yes.
It will be. Okay.
Correct.
Okay. That's all I have. Thank you very much.
Thank you very much. Thank you.
Excellent. Thank you, Senator Bragg. Ms. Metz, I might just give you a final question. And I note as I said at the outset of following your opening statement, that no doubt a great deal of work has been done by members of your team in this regard. So one of the high-level themes coming out of the submissions is there's overwhelming support for the CCIV for the reasons which have been pretty well ventilated, but there's a sub-theme which is the structure around it in terms of regulation, etc., could be improved. So it could be enhanced over time. That shouldn't hold up this bill. Need to get the bill in place as quickly as possible so people have certainty as they look towards that deadline, but it can be enhanced as we move forward. Is that something which is at a high level, from a high level perspective on ASIC's agenda, that the journey doesn't finish just as soon as this bill's passed and we hit that 1 July deadline, but we need to look forward in terms of how we can continually enhance and make sure that it remains a competitive corporate structure?
Thank you for that question. Look, I think that is 100% right. So Treasury will be able to talk to that aspect. But yes, we are in ongoing conversations with Treasury around a range of issues, and we'll continue to work with Treasury on any enhancements that need to be made.
Excellent, excellent. Thank you very much. So, Ms. Metz, thank you for appearing as a witness today, and Ms. Eccleston, again, thank you for appearing as a witness today. I'd ask that you now disconnect from the video conference. You can continue to observe the hearing should you wish to do so from PAL View. Thank you for attending today.
Thank you for your time.
Thanks very much.
I now welcome representatives from the Australian Taxation Office. Thank you for appearing before the committee today. I remind officials that the Senate has resolved that an officer of a department of the Commonwealth or of a state or territory shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policy or factual questions about when and how policies were adopted. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise you that any questions or notice should be sent to the Secretariat by close of business Tuesday, 25 January 2022. And I note that's an aggressive timetable, so I do appreciate any assistance you can provide us in that regard, given our reporting day. I invite you to make a brief opening statement, should you wish to do so. And for the Hansard record, could you please state your name and the capacity in which you appear?
Thank you, Senator. My name's Andrew Werbick. I'm an Assistant Commissioner in the Policy Analysis and Legislation area of the Tax Office.
Thank you.
Hi, I'm David Kazmarek. I'm an Assistant Commissioner in the Public Groups and International area of the Tax Office.
Thank you. And who, I think we have a, yep, hello.
I'm Amy James-Verlargett, Assistant Commissioner for Private Wealth of the Australian Taxation Office.
Thank you for joining us. And Mr. Ryan? You're on mute, Mr. Ryan. You're the first one to do that today, but you won't be the last.
Yes, thank you. Hi, I'm Chris Ryan. I'm an Assistant Commissioner in the Private Wealth area of the Australian Taxation Office.
Thank you. Thank you for joining us, Mr. Ryan. And I think we've got Mr. Dixon with us.
Apologies, I'm for the next session, Senator.
Oh, sorry, Mr. Dixon. Okay, so I think those are all our witnesses from the ATO. Mr. Werbick, do you or any of your colleagues have an opening statement?
No, we don't, Senator. Happy to get straight into it.
Right, no questions. Okay, well, let's do that then. And over to you, Senator Chisholm.
Thanks, Chair. I just wanted to get some clarity on this. So that my understanding is the government's proposal is for the tax treatment of CSIVs to replicate the existing tax treatment of Australian Managed Investment Trusts. Is that correct?
That's correct.
Okay. So how will the ATO ensure regulatory parity between managed investment trusts and CSIVs?
Well, the approach that the legislation takes is to essentially take what is a legal form company with shares on issue to be seen for all relevant tax purposes, unless there are exceptions, as being on the same footing as a attributed managed investment trust. What that means is that from a administrative perspective, when we put together forms and have system builds and put out our public advice and guidance, then we will be explaining what that means in practice, and that as far as possible, the CSIV as a corporate vehicle will be given the same tax treatment as an AMIT, unless it fails the requirements.
Okay. Does the ATO have any estimates of the existing tax gap, that's the gap between tax due and tax payable, in the existing Australian funds management industry?
I'm not aware of any such tax gap work, but I'll invite Mr. Kazmarek to supplement my answer.
Yeah, look, I'll probably have to take that one on notice, and we can come back to you with an answer on that.
Okay, I had a follow-up on that, if you could take that on notice as well, about what strategies does the ATO currently have in place to reduce this gap?
Well, that's on the assumption that there is such a gap. As I said, I'm not aware of. I mean, we've got a number of tax gap analyses that have been released over the last couple of years, spanning a number of different taxpayer populations and sectors. As I said, I'm not aware of there being any such work in relation to the fund management industry, but we can take that on notice.
Yeah,
How much in terms of... Sorry, go on.
So I'll probably just add to that there is a large corporate tax gap which covers the full industry, including I suppose the private wealth tax gap as a subset. And we have a justified trust program that covers the markets in the entirety of which those funds sit within. But I suppose if we want to get down to the specifics, as we mentioned before, we'll take the question on notice.
Thanks. How much in terms of resources does the ATO dedicate to current oversight or enforcement activities for managed investment funds and managed investment schemes?
Senator Chisholm, are you there or have you dropped out? You're not going to answer that question if you've dropped out, obviously.
Can you hear me okay now?
All right. Okay. Well, look, until we get Senator Chisholm back, I might. I've got some questions in relation to some points that have been made by King & Wood Mallesons and also the Financial Services Council, Mr. Werbick. So I suspect I should direct these to you. And I should say first, I appreciate or I can try and appreciate the complexity of all this from an ATO perspective. I've got no doubt there's been a tidal wave of work to go through in terms of trying to make all this work. So I really do appreciate the complexity. And in terms of the questions I'm going to ask, it all comes from a place of we want to make sure this vehicle, CSIV, is as attractive as possible and make it as easy as possible and attractive as possible to get that inflow of foreign investment into our funds management industry. So that's the basis upon which I'm putting these questions to you. So have you had a chance to review the King & Wood Mallesons submission, Mr. Werbick or Mr. Kazmarek?
I haven't reviewed the King & Wood Malleson submission to the inquiry, but am generally aware of, I guess, some industry feedback.
I'll run through some points which they make, and I'll go through paragraph by paragraph, and you can feel free to take them on notice. But I think it's important to flush out some of these issues. So to quote from page 3 of their submission, the first paragraph, one aspect that could be improved is the specific provisions of the bill which deal with the taxation of a CSIV sub-fund in the event widely held conditions are not satisfied. The appropriate policy is to produce an equivalent outcome to that which would apply if the corporate collective investment sub-fund was a MIS, managed investment scheme. The current drafting does not achieve this policy objective, end quote. So not wanting to get into the policy aspect, there is a concern that the drafting itself doesn't achieve that particular policy outcome. Is that something you could respond to?
Yes, well, insofar as the policy question as to whether that's the appropriate treatment for a sub-fund that has failed, I'll defer to my Treasury colleagues to provide some additional information or insights into that. In terms of whether the drafting achieves the objective of, I guess, operationalising the fact that the CCIV is a company with its tax treatment if it should fail, and therefore applying Division 6 General Trust Principles or Division 6C Public Trading Trust rules. We haven't come across any specific issues, but look, that is part and parcel of implementing a new measure with our public advice and guidance program to set out in more detail about how these provisions work. And the ATO is actively working through, or at least starting to think about what sort of public advice and guidance might be needed.
Okay, and I note that Senator Chisholm, you've come back, so I might, Mr. Werbick, I'll continue. I've got a few points that are raised in some of the submissions. I do want to put on notice with you, but I'll hand the call back to Senator Chisholm so he can continue his line of questioning first. Senator Chisholm.
Thanks, Chair. I just wanted to ask how much in terms of resources...
Senator Chisholm, you there?
Yeah, you can't hear me still? Can you hear me now?
All right. Well, I might, Mr. Werbick,
Hello?
we might continue. So Secretariat says they can hear Senator Chisholm. Mr. Werbick, can you hear Senator Chisholm?
No, I cannot.
All right. So I can't hear him either. So there seems to be an issue there. So I might just continue some questions for 5 minutes until we can get him back. So I might finish this line of questioning and then we'll go back to Senator Chisholm. The second point they raise, and this is an issue that's raised by a number of submitters, including the Financial Services Council and also Pitcher Partners, and that is, and I quote, "A second area for improvement is the requirement in the legislation that the amount to which beneficiaries must be presently entitled is based on accounting profits. This will be inconsistent with the way funds normally operate. The reliance on accounting profits can in some cases potentially produce inappropriate outcomes for members. We believe that a simple solution to the problem is to remove reliance on the concept of accounting profits and rely on the definition of income stated in the CCIV's constitution, which would align with the concept of trust income for a managed investment scheme," end quote. Do you have, are you in a position to give any thoughts with respect to why it is that at the moment the amount to which beneficiaries must be presently entitled is based on accounting profits as opposed to adopting the alternative approach proposed by King and Wood Mallesons?
Similarly, Senator, I think there's a clear policy choice that's been taken on the form of the legislation to look to accounting profits, and as such, I think that would be more a matter of the Treasury to opine upon.
Okay, all right. And the third point they raise, quote, "It would also be beneficial to improve the tax rules that rely on the concept of a dividend, which is not the same as the MIS concept of a distribution," end quote. So this concept of a dividend not being the same as the MIS concept of a distribution. Do you have any view? Is that another policy issue?
I suspect it is. I did see in the FSC submission some mention of problems that the ATO would encounter with the dividend concept. I'm not aware of that being a particular issue for us. Insofar as I said, the legislation takes the approach that, look, it is a legal form company. We're going to, for all relevant purposes, switch that off and have a deeming provision that essentially requires the CSIV vis-a-vis its sub-fund and its beneficiaries to be taxed as a trust, as an AMIT. To the extent that there are things that need to be clarified, then we'd certainly take that on board in our public advice and guidance, subject to prioritisation.
Okay. All right. Senator Chisholm, are you there? Oh,
I am. Can you hear me?
so I can't hear Senator Chisholm, Mark. But can anyone else hear Senator Chisholm? Any of the witnesses?
No, I can't.
No. Okay. All right. Mr. Werbick, I might. There's a number of concerns raised in the submission from Pitcher Partners as well, and that includes the topic we've just discussed. I'll quote from paragraph 5 of their submission. We attach at the appendix a preliminary list of issues that we've identified. Most of these issues are in relation to applying the deeming rules in proposed Division 195 to the Income Tax Assessment Act 1997, which relate particularly to those CSIV sub-funds that do not meet or at risk of not meeting the criteria to be taxed as an attribution managed investment trust. In particular, our main concern is the use of profits as a proxy for the income of a trust estate for a non-AMIT sub-fund. We believe the use of this concept will be problematic from an ATO administration as well as a taxpayer compliance perspective. We believe that the difference between this term and taxable income will likely result in many cases where a CSIV sub-fund is taxed at 47%, end quote. Do you, and maybe you can take that on notice if you like, but do you have any initial response to that proposition?
Yeah, look, the matter that you raised there is where the CSIV in right of the sub-fund has failed, and it may do so in circumstances where it may no longer be widely held or it's no longer carrying on passive activities. Now, what that does is it takes it out of the AMIT sphere of taxation and into Division 6. Now, as a general proposition, the AMIT rules themselves were brought in to overcome many of the issues of a long-standing nature that is found in Division 6 vis-a-vis general trust taxation. It's not a place where you would necessarily want to end up as a CSIV in right of the sub-fund. In terms of the specific issues that the submission appears to have raised, I suspect that they are matters for Treasury insofar as they are wanting changes to the law, and that itself may involve some policy questions. But aside from that, look, happy to take that one on notice in terms of the granularity of the suggestions that are made.
Okay.
But at first blush, I think they go towards the question of how ought the world of Division 6 taxation apply to a failed CSIV. We hope that they won't be failing, of course, but yes, happy to take that one on notice.
Okay. Well, if you could, Mr. Werbick, and they've attached a schedule of comments to the letter in relation to particular sections and raise queries. It's very extensive, but if I could ask you if you could have a look at that schedule, and to the extent that there are matters which don't broach on policy, if it is possible, if you could give any feedback in relation to the 23 items they raise, and even if it's short form along the lines of this is a policy question or this is something ATO will look at in terms of developing guidance as we move forward, that would be useful for the committee. Would that be possible, Mr. Werbick, for you to take that on notice?
We can take that on notice and have a look at the list and provide a suitable response.
Okay, thank you. Thank you very much. I appreciate that. Senator Chisholm, are you there?
I am. Can you hear me?
I can hear you. I can hear you now. So over to you.
Thanks. How much, in terms of resources, does the ATO dedicate to current oversight/enforcement activities for managed investment funds and managed investment schemes?
I'll refer that question to Mr. Kazmarek.
Yeah, look, we have strategies within our broader pool of funding that look at those areas of the market. The precise percentage or budget number of that total I haven't got handy, so I can take that on notice. But certainly we have resources in place that are currently looking at that area of the market currently.
Okay. Yeah, if you could provide some extra detail on notice, that'd be great.
Yes. Yep.
The government says these changes may result in significantly increased capture of the global funds management industry by Australian firms. If the amount of funds under management increased significantly, would the ATO need to devote any additional resources to enforcement and oversight?
So there's probably a couple of aspects to that question. Firstly, funds under management may increase, but do the number of funds increase? So I'd probably take the question as a bit of a hypothetical. If the former, so the funds under management increased, but the number of funds didn't increase, we are probably able to use our existing assurance measures to cover the increased numbers in the market. But I mean, there's a whole bunch of aspects to that answer. Does the range of activities conducted by the funds increase? Does the range of number of funds increase? If the answer to those questions is yes, then I would say yes, we would need to dedicate further resources.
Okay. Just in relation to employee share schemes, how much did the ATO collect in taxes in the last financial year as a result of the cessation of employment provision?
So I'll probably suggest we'll take that one on notice, Andrew.
Well, I'll throw that question to Mr. Ryan from our private wealth area for any comment.
Hi. I would also have to take that on notice to determine precisely how much we collected in receipts from cessation of taxation of employee share schemes. So.
Okay. And I had a follow-up question. If the ATO has any distributional data on the tax collected, for example, how much of that tax was collected from the top quintile of taxpayers?
Likewise, I'd also have to take that question on notice.
Okay. Thanks, Chair. That's it from me.
Thank you, Senator Chisholm. Senator Bragg, do you have any questions? No, I might just ask another question in relation to the employee. Oh, Senator Bragg.
Sorry.
You're right. Do you have questions?
I do. Just a quick one, Chair. So just in lay terms, the tax difference between investing through a MIS or a CCIV is what exactly?
Well, one of the benefits of a MIS entering the AMIT regime is that there is character flow through that is recognised for things like non-assessable, non-exempt income, exempt income, certain tax offsets. That's a really significant advantage. Another advantage is with the unders and overs mechanism, and so whereby if you are a MIS and therefore you don't have access to the unders and overs regime, then if there are any variances between your income and your the income that's been distributed to your beneficiaries, then there is under Division 6 an increased exposure to tax, whereas an AMIT will be able to sort of just roll with the punches, so to speak, and merely make good in the year that they are identified, generally speaking.
So I guess my question is though, but what is the difference between, what is the difference going to be from a tax point of view of investing via a CCOV or an MIS? If they're both if they both get access to the AMIT regime, what's the difference? Is there any difference?
Well, if you've got a MIT that has made the election to go into the AMIT regime, and you've got a CCIV in right of a sub-fund that is also being taxed as an AMIT, then in light of the alignment that is expressed in the legislation, it's intended that there not be any difference, all things being equal.
Okay. And you're confident that can be, there's no barriers to that harmonisation occurring?
We haven't identified any critical reasons why that wouldn't be the case.
Outstanding. Thank you, Chair.
Thank you, Senator Bragg. I just had one final question in relation to the employee share schemes, and that is after this, well, assuming this amendment is made with respect to cessation of employment, the taxing point with respect to shares, options, whatever that are issued to employees, what will be the relevant taxing points left after cessation of employment falls away? If you could answer that question.
Pardon me, that'd be a question for me.
Mr. Ryan.
Yes. So the relevant taxing points then remain as where there's when a real risk of forfeiture of the share or right to acquire the share no longer exists. So that would be the key alternative taxing point that would most commonly occur.
Okay, so and because of the way employee share schemes have developed with clawback rights, etc., if you have a situation where someone was a senior executive, they've left employment, but once they've left employment, there are no clawback rights or any risks in terms of their shares. They're still going to be taxed at that point. Is that correct?
That's correct. So where they no longer have any risks of clawback, then that would be the point at which taxation would occur.
Okay, right, understood. So situation where someone leaves employment, but they've got shares which are still subject to forfeiture because they're outstanding key performance indicators or something, the benefit of this reform is they don't get taxed at the point they leave employment. They get taxed at that latter time when that risk of forfeiture, etc., falls away. Is that correct?
That's correct. I would also just add, though, that being the primary deferral, there is also a maximum period of deferral of 15 years as well.
The maximum period of 10 years as well. Okay.
Sorry, I said 15.
Oh, 15 years. Okay. Thank you. Thank you, Mr. Ryan. That's most helpful. All right. So thank you to all of the witnesses from the ATO. I understand that we have given you some homework, Mr. Werbick. So I know it's an aggressive time, but whatever timetable, but whatever assistance you can provide us would be gratefully received, especially because these issues have been raised with us. So we would like to give some sort of response as we prepare our report. So with that, I thank all the witnesses for appearing today. I'd ask you now to disconnect from the video conference. You can continue to observe the hearing should you wish to do so through the live stream on Parliament's website. Thank you very much.
Thank you, Chair.
Thank you.
Thank you.
I now welcome representatives from the Treasury. Thank you for appearing before the committee today. I remind officials that the Senate has resolved that an officer of a department of the Commonwealth or of a state or territory shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked to the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Information on procedural rules governing public hearings have been provided to witnesses and are available or is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones and please ensure your microphone is set to mute when you are not speaking. I would also like to advise you that any questions on notice should be sent to the Secretariat by close of business Tuesday, 25 January 2022. I invite you to make a brief opening statement should you wish to do so. And for the Hansard record, could you please state your name and the capacity in which you appear, please? So who wants to lead off?
So I'm happy to lead off. I'm Tom Dixon, Assistant Secretary, Corporations Branch, and we won't be making an opening statement.
Okay, thank you, Mr. Dixon. Next. Anyone else like to say anything at this stage, or will we go straight to questions? We might just go straight to questions, and when questions are put, if the first time you respond, if you could please just state your name and the capacity in which you appear for the benefit of the Hansard record, that'd be much appreciated. So, Senator Chisholm, over to you.
Thanks, Chair. Can you outline the measures in place to ensure regulatory and taxation parity between CSIVs and managed investment schemes and trusts?
Thank you for the question. So Tom Dixon speaking. In terms of parity, when we think about parity, we think about making sure that all of the features of MIS regimes that make sense to include in a CSIV regime, we've attempted to make sure that those have been brought across for this phase of the work that we've been doing. And but I wouldn't want to leave you with the impression that parity has been the only objective that we've been pursuing, because naturally the rationale for having a CSIV regime is to attract overseas capital, particularly from entities that are less familiar with a MIS regime and from entities that are more familiar with a corporate structure. And so necessarily when we think about a CSIV regime being based around a company structure, it's natural then that we would be importing with that regulations that are appropriate for the regulation of company structures. So, we've taken great measures to actually, achieve some degrees of consistency and parity where that makes sense. But obviously there are places where we've had to deviate from that because it goes to the actual objectives of the CSIV regime itself in attracting offshore capital. So in terms of, things that perhaps on the tax side, that we could throw to first, I might ask some of my colleagues just to talk about parity on the tax side.
Hi, David Hawkins, here, Acting Director in the Special Tax Regime. So on the tax, the CSIV tax framework, the guiding policy intent is to provide equivalent tax outcomes with what happens already in the tax law. And so the way we do that in the CSIV context is we have an overarching deeming principle. And to maybe oversimplify it a little bit, but to present it in a layman's term, the deeming principle you can view almost as definitional in the sense that it defines what a deeming principle is, and then it hooks into the existing mechanisms, existing tax concepts that already occur in the law. And from that basis, the broad intent of the CSIV is that the CSIV sub-funds will be taxed like an AMIT, And so you can take that reference to broad intent as us anticipating that the vast bulk of sub-funds will be taxed like an AMIT. Otherwise, they would fall into the CCF sub-funds, that is, would fall into the existing Division 6 principles that already occur in the law. So that's how we seek to endeavour to provide for similar tax outcomes between CCF sub-funds and what happens currently.
Thanks for that. Does Treasury expect that existing managed investment schemes or trusts will transition to the new form? And if so, what percentage of existing fund under management are expected to move to the new form?
Thanks for the question. It's Tom Dixon speaking here. So we do expect that there'll be a degree of transition. We know that there's been appetite because we've received submissions from the industry saying that they have that appetite. By way of background, I mean, one of the things that underpins some of that appetite is in selling a new regime in Australia overseas, it helps to have an established number of funds already in existence. So we understand the point that's been made, but we haven't done any modelling on how many will transition or when. So we don't have a reliable estimate of that.
Okay. Just on employee share schemes, Treasury has indicated that the revenue impact of this bill would be $345 million in the first year. Does that revenue impact account for behavioural changes? For example, more remuneration being provided in the form of ESS as a result of these changes?
So I'll ask my revenue group colleague to answer that one.
Senator, I think we'd have to take that one on notice. Our area of expertise is limited to the CCF, but we can talk to our colleagues and get back to you.
Okay. And has Treasury conducted any review of the distribution of this revenue impact?
Similarly, yeah, we'll have to take that one on notice for you.
Okay. Just on the retirement income covenant, Super Consumers Australia in submission 14 outlined significant concerns in the self-managed superannuation fund space in relation to self-managed super funds and retirement income. Similar issues were raised in relation to the Treasury Laws Amendment Self-Managed Superannuation Funds Bill 2020, and as a result, the government agreed to a statutory review provision in relation to the bill, which is due to be completed before the end of this year. Does Treasury have anything that they'd be considering in relation to the concerns raised by Super Consumers Australia?
It's Adam Hawkins, Assistant Secretary, Tax and Transfer Branch here. The circumstances of our self-managed superannuation fund and an APRA regulated fund are quite different as it relates to the retirement income covenant. So an APRA regulated fund obviously has a very large membership, potentially millions of members, and will need to gather information in order to formulate their strategy, whereas a self-managed superannuation fund will intimately know their members, and so the need to gather information and then develop a strategy on the types of services or products that might be appropriate to them isn't as involved as it would for an APRA regulated fund. And so for that reason, they can be thought of quite differently in terms of what the right set of regulations that might apply. And so for that reason, the government's made the decision to not cover self-managed superannuation funds with a covenant. I'm not 100% over the review that you mentioned, but I might just check with my colleague, Mr. George, to see if he has anything to add.
Yeah, thank you. Jordan George, Director in Tax Transfers Branch, Treasury. Unfortunately, at this point, I don't have anything to add to my colleague, Mr. Hawkins, and perhaps we can take that one on notice in regards to that statutory review.
Okay. Has Treasury collected any data on retirement incomes outcomes in relation to self-managed super funds, either as part of the preparation for this bill or previous work, including the retirement income review?
So there is some detail in the retirement income review, and there is some information that Treasury would have available to it. If you're able to clarify further what you're interested in terms of outcomes, we'd be happy to take on notice for further detail.
Yeah, sorry, just to try and clarify, I suppose, how does it compare to outcomes in the rest of the superannuation sector?
Well, so the distribution of balances in self-managed superannuation funds looks quite different to the distribution of balances in APRA-regulated funds. And so the nature of drawdown by self-managed funds will be quite different. As I said, we can take on notice in terms of some of the analysis that was done for the retirement income review and provide that to you.
Thanks, Chair.
Thank you, Senator Chisholm. Mr. Hawkins, I think I've got some questions for you in relation to the murky world of taxation and CCIFs, which I've become an expert in the 3 hours of looking at it late last night. So just bear with me if my questions are somewhat naive or it takes me a while to get to where I need to get to elicit information from you. So there've been a number of submissions in relation to the taxation treatment of CCIFs from some stakeholders, King & Wood Mallesons, so some of their legal experts who deal with this area, Pitcher Partners, and also from the Financial Services Council. And I guess the best way to walk through this is to put a series of propositions from King & Wood Mallesons' letter. And I don't know if you've had a chance to have a look at this, but I'll read each of the propositions, and if you can provide at least some feedback from your perspective as to what the intention is underpinning the existing legislation and why there's a disparity in views. So the first one is, I quote, "One aspect that could be improved is the specific provisions of the bills which deal with the taxation of a CCIF sub-fund in the event widely held conditions are not satisfied. The appropriate policy is to produce an equivalent outcome to that which would apply if the corporate collective investment sub-fund was a managed investment scheme. The current drafting does not achieve this policy objective," end quote. So I guess the question is, what is the policy objective in terms of this particular issue that we should be seeing reflected in the legislation, and is there a discrepancy between the legislation and the policy objective?
Thank you, Senator. So yeah, you are right. These sorts of areas do take us into some very, very technical law design concepts, but I will endeavour to bring it up a level and talk you through it. So at a high level, as I outlined earlier, the intent from a CCIF tax framework perspective is that the tax outcomes that are available in what we would call the base world or the existing world, so whatever an AMIT gets currently, that is intended to carry over into the CCIF, and we do that via a deeming principle. And so from that perspective, a sub-fund of a CCIF will always start out as an AMIT. However, and so in that sense, the broad intent is that the sub-funds of a CCIF will be taxed like an AMIT. Our understanding of the market practice is that it's very, very rare for a fund that wants to operate as an AMIT to ever fall out of those tax rules. There is a safe harbour that exists in the law currently for what we would call temporary circumstances that are outside of the influence of the trustee. So maybe, for example, one investor that has a lot of capital in the fund redeems their capital and momentarily or for a period of time, that fund would be deemed to be no longer compliant with the AMIT rules, but there is a safe harbour in play to keep them in the AMIT rules, and that's to everyone's benefit. So yeah, our understanding of the market practice is it's very, very rare for a proper AMIT to fall out of those rules. That said, it does leave a cohort of funds out there who what we would describe as a non-AMIT, so a fund who would never be an AMIT. And so what happens in terms of their tax outcome? As I outlined earlier, the intent is to carry over what they get currently, and that is the Division 6 tax principles. And as our ATO colleagues, and I think yourself alluded to earlier, that is a very complex area of law, and the concepts of present entitlement and the like, it's notoriously complex. And so what the stakeholders are asking, as we understand it, is that in those instances, maybe we can look past the widely held requirements and allow all sub-funds of a CCIF to be taxed like an AMIT. But when we look at that, so the reason we have the widely held rules in the first place is there are probably like a core long-standing integrity rule that governs the concessional tax outcomes of a MIT or an AMIT. And when we think about, do you almost look through that widely held rule and allow all funds to be able to access the concessional tax outcomes of an AMIT? For us, that starts to raise broader tax framework questions that we think are beyond the immediate purpose of this CCIF bill. But going back to the core point here, we don't think that the lack of a widely held, we think that enforcing the widely held rule for funds that aren't widely held does not take away from the policy intent of the CCIF.
Okay, and you made the point, Mr. Hawkins, that there's a safe harbour for in the event that a fund temporarily falls within the ambit of that not widely held rule because a major investor is redeemed or something to that effect. Is that correct?
Correct, yes.
Okay. Well, Mr. Hawkins, you answered that question very well. I understood it. So it's well done. So we'll see how you go on the next one. A second area for, and I quote, a second area for improvement is the requirement in the legislation that the amount to which beneficiaries must be presently entitled is based on accounting profits. This will be inconsistent with the way funds normally operate. The reliance on accounting profits can in some cases potentially produce inappropriate outcomes for members, end quote. And this is an issue, I should say, Mr. Hawkins, that's been touched upon by the Financial Services Council and also Pitcher and Partners. So if I could get your response to this issue of accounting profits.
Yes. So this area of the CCIF tax framework, I think it's fair to say it was a focus of the consultation with stakeholders. And so, yeah, the views are well known to us. I think, so as I alluded to in the earlier response, the reference to present entitlement, even at the best of times, is very difficult to navigate. And the point that the stakeholders were making, as we understand it, is that carrying over that concept into the CCIF provides unnecessary complexity. I think that's the point they're making. As our ATO colleagues alluded to earlier, this is one of the reasons that the AMIT rules were implemented in the first place. So going back to 2016, the whole essence of those rules was to provide a set of special tax rules for what we would call widely held collective investment vehicles that are typically highly capitalised, to provide them with more certainty, more flexibility in how they make their income payments, and to basically take them out of the world of present entitlement. The other point I'd make is that we are dealing with what we would describe as a small minority of funds here, noting that the broad intent of the CCIF framework is that the CCIF sub-funds are taxed like an AMIT. That notwithstanding, we understand the stakeholders' views around needing the clarity and the certainty in the law. We think that the law still provides that. I would point you to the explanatory memorandum, and I think it is starting at paragraph 13.89 that steps out how the income of a sub-fund is intended to be calculated. And we agree that the reference to accounting profits is a different concept as to what they would have to deal with currently. But I think we have to look at that in the context of what we're dealing with. We're talking about a CSIV, which is a corporate entity. And I think this is a good example of where the CSIV has to be looked at as one. So both the regulatory framework and the tax framework together. And ultimately the CSIV is a corporate entity. It has a regulatory framework that provides for that. It includes your corporate law concepts like dividends and solvency. And ultimately, because we are dealing with the CSIV, we do have to respect that. A high-level example is that the CSIV will pay out a dividend. A trust will never need to do that. So there's already a difference there. And so what our deeming principle is seeking to do is to make certain that the outcomes that a fund can access currently carries over to the CSIV. And we think that the bill does that. There's various scenarios in the explanatory memorandum that steps out how the concept of accounting profits is meant to relate to taxable income. And so, yeah, I would point senators to that if it would be helpful. I think just to maybe preempt another question that you may raise around the prospect of a 47% tax rate and will a CSIV sub-fund be worse off? Because I think I heard the ATO ask this. We would look at that as, if that is the case, whether that happens currently as well. So the broad takeaway there is we don't think the CSIV is doing anything different to give rise to that different tax outcome.
Okay. All right. Again, thank you very much. And I'll put this third proposition to you, and I think you've touched upon this in terms of your response regarding the nature, the difference in terms of the legal structure and the fact that the Corporations Act provides a whole regime of regulation in terms of dividends, solvency, etc. But the third proposition from King and Wood Mallison's letter is, and I quote, "It would also be beneficial to improve the tax rules that rely on the concept of a dividend, which is not the same as the managed investment scheme concept of a distribution," end quote. So I think your previous comments addressed that point. Is that correct, Mr. Hawkins?
Yeah, that is correct. And I also, our colleagues earlier from the ATO, when we were working on the CSIV framework, we obviously worked very closely with the ATO, and I think the ATO made the point earlier that they don't see any complexities from their part or any difficulties from their part in having the concept of a dividend applying in this instance. But you're right, ultimately it is recognising that we are dealing with a corporate entity that ultimately pays out dividends.
Yeah, okay, thank you very much. Well done, Mr. Hawkins. Mr. Dixon, if I can maybe ask you some higher level policy issues. And the first is a proposition which I put to ASIC earlier today, and that is a common theme across all of the submissions in relation to CSIVs is it's really good that we've got to this stage. Strongly recommend the bill, which is being considered by Parliament. Pass the bill as quickly as possible to give us certainty, but also that there can be some further enhancements, some further development to make CSIVs in an Australian context more attractive and to achieve that ultimate policy goal of maximising the inflow of funds for our funds management sector that underpins the policy reason for the legislation. So from your perspective, from Treasury's perspective, is it fair to say that the journey doesn't just stop when this bill is potentially passed, but it continues in terms of making the necessary tweaks and enhancements to make this regime as attractive as possible.
Yes, I would agree with that. Naturally, it's a matter for government as to what they prioritise from this point forward, but it's our intention to keep working with the sector. We've heard the feedback throughout the process that there's a very strong support to proceed with the bill, and we've also heard the feedback that over time there'll be things that will be worth considering in terms of making future enhancements, adding features to the core framework that's been established. And we remain interested in understanding those things and working through them.
Is there any? Do you have you set up any structure to enable that continued engagement once the bill has been passed? Is there a team that will continue to work on these issues with industry? Is that correct?
Yep, that's correct.
Okay, excellent. And then my final question is in relation to the transitional regime. So again, one of the matters in terms of enhancements is how we make sure that the managed investment scheme of today, if it wants to transition under the new CCIV regime, that it should be able to do that without any adverse tax consequences or other administrative issues. Is that one of those enhancements you're looking at, or is there something already in train to address those sorts of transitional issues?
So it's definitely one of the things that we're looking at.
Okay. All right. Excellent. All right. Well, with that, I don't have any further questions. I might just ask my colleague, Senator Chisholm, are you okay? You've got no further questions?
All fine, thanks.
Okay, thank you, Senator Chisholm. So if I could thank all the witnesses from Treasury for appearing today. Mr Hawkins, I note that you took the lion's share of questioning and handled it most ably. So thank you for all of your efforts, and everyone else on the team, all of your efforts in relation to this important reform. It's greatly appreciated. I would ask that you now disconnect from the video conference, and wish you all the best for the rest of your day and week. Thank you very much.
Thank you.
And that concludes today's hearing. On behalf of the committee, I'd like to thank all those who have made submissions and sent representatives here today through video conference for their cooperation in this inquiry. And the committee now stands adjourned. Thank you very much, everyone. Thank you, Broadcasting, as well, for helping with those issues. Thank you. The Senate Economics Legislation Committee for the Inquiry into Corporations Amendment Improving Outcomes for Litigation Funding Participants Bill 2021. The Senate referred this inquiry to the committee on 2 December 2021 for report by 3 February 2022. The committee has received 15 submissions, which are available on the committee's website. This is a public hearing, and a Hansard transcript of the proceedings is being made, although the committee may determine or agree to a request to have evidence heard in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as contempt. It is also contempt to give false or misleading evidence to a committee. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may also be made at any other time. Witnesses should speak clearly and into the microphones to assist Hansard to record proceedings. I'd also like to advise witnesses that answers to any questions on notice should be sent to the Secretariat by 24 January 2022. And I note that is an aggressive timetable because the reporting date for this committee. So really do appreciate any cooperation you can provide in that regard. I ask everyone to ensure that they've switched off or turned their mobile phones to silent. I now welcome representatives from Marland Law, Submission 8, and the National Farmers Federation, Submission 14. Thank you for appearing before the committee today. I invite you each to make a brief opening statement should you wish to do so, And for the Hansard record, I ask each of our witnesses if they could first please state your name and the capacity in which you appear. So, Mr. Marland.
Yes, good afternoon, Senator, and to senators on the committee. Thank you for the opportunity to appear today. I'm a solicitor who works for Marland Law, based in Central Queensland, Bundaberg, and I'm involved in a number of large class actions involving impacts to affected landowners up here in Queensland. And while I'm not a class action expert, I have had dealings in class action space over the last 5 to 6 years, and have been following the progress of not only this bill, but the early amendments to the Corporations Act that were passed in 2020, I believe, to see how that practically impacts the ability to run a class action, and more importantly, to fund a class action. I guess in relation to this proposed bill, I have filed a submission, rely on the material that's put there. I guess in relation to this, I seek to make 3 main points. The first is, for me, that really stood out when I looked at this bill, is I looked at the Australian Law Commission report into class actions, which was an extensive investigation into the class action regime in Australia. And there was some very well considered and very insightful recommendations that came out of that report. And it is, for me, quite dumbfounding actually to see that out of those recommendations, not only there were effectively none of them adopted in this particular bill, but some of them are actually directly overturned. And that is a great concern, because the Australian Law Commission report had extensive stakeholder engagement on both plaintiff, defendant and litigation funders, and across a wide variety of industry groups. And I think it is remiss of this Parliament to completely ignore the work that went into that process. And I think that is a process which the Senate, as a House of Review, should strongly uphold, that processes and procedures are maintained, and that proposed bills, don't directly contradict the work that's already gone into those processes. The second main point I make, and I do it in my submissions, is the whole point of class actions is to balance the ledger for plaintiff groups. So you're talking about mums and dads, individual Australians who have been some way wronged against, and most of the class actions are run by ASX listed top 100 companies, state governments, federal governments, who seemingly have unlimited resources to defend themselves. And class actions is a way of balancing that ledger. And while I understand the intent of this bill is to deliver fairness to plaintiff groups, what effectively this bill will do, it will reduce access to justice for thousands of mums and dad Australians. Because without a litigation funder, without being able to balance the ledger, it is impossible, effectively impossible, to run many of these class actions. And I'm talking about class actions like the Brisbane Floods class action. I'm talking about the bushfires class action. I'm talking about the PFAS class action, which the federal government's acutely aware of. These cases would not have been run and would not have been won, and there would have been no recourse for those individuals without the use of litigation funders. The third point that I make, and I make this probably from a practical point of view, is that this bill has great difficulties from the first outset because it's got constitutional problems. And from a practical point of view, this is what will happen if this bill's passed, is class actions will just be run in state jurisdictions. And I think the federal government needs to reach some sort of arrangement with the states before it even contemplates passing this bill, because it will simply be pushed to different jurisdictions. And that will be a great loss to our class action regime, because our federal courts, our federal judges are the most experienced, the most resourced, and the ones that should be presiding over these class actions to make sure they're done economically and efficiently and in the best interests in both plaintiffs and defendants. And the other point that I'll quickly make before I wrap up is the unintended consequences of this bill is simple. If you put a cap on a plaintiff, litigation funder can charge and what the lawyers can charge, defendant lawyers will use that as a strategy to effectively bat out time. They will delay, they will frustrate, they will use that as a direct process to frustrate out not only the economic and the efficient use of our judiciary, but they will use that as a battering ram to effectively starve out plaintiff groups, and it will reduce or disincentivise early settlements of these matters. And it is remiss of this Parliament to seek to statutorily restrict the ability of a plaintiff to represent themselves, with also not looking at the conduct of defendant lawyers and defendants themselves. And this bill will directly lead to very perverse outcomes, and I think it needs to be completely reviewed.
Thank you, Mr. Marland. Now, our witnesses from the National Farmers Federation, would you like to introduce yourselves and then provide any opening statement you might have?
Yes, thank you, Senator Scarr. Can you hear me okay? I've been having a little trouble with my internet this morning. So
I can hear you, and I see Senator McDonald nodding sagely, so she can hear you. Yeah.
Excellent. So my name is Ben Rogers, and I'm the General Manager for Workplace Relations and Legal Affairs at the NFF. And appearing with me is Nathan Panetta, who's a policy officer who works with me. My interest in this bill is in my capacity as Secretary for the Australian Farmers Fighting Fund. The Australian Farmers Fighting Fund is not strictly speaking, well, not primarily a litigation or class action funder, but it has funded one class action in the past. So for that reason alone, it would be caught by the changes to the legislation. That said, we're not overly concerned about these changes. We just think that it's a good opportunity to address some of the concerns that Mr. Marland just mentioned around defendants dragging out proceedings and relying on court procedure to effectively exhaust plaintiffs and class action plaintiffs. So just for background, the Australian Farmers Fighting Fund was established in 1980 to fund the legendary dispute, which was a workplace relations issue involving a meat processing plant. It is principally almost solely concerned, in fact, it is solely concerned with funding litigation, which is of importance to the farming community. It's not about making money. It's not about a return on an investment or anything like that. It is simply about funding litigation, which is significant to the farming industry and will have an impact upon the industry, or defending actions, which will have an impact upon the industry. It does only recently, and as I said, so far only once, sort of return when it engages in funding a class action. That return is limited to 10%, in this case, 10% of the damages claim. And that is solely so that it can continue to operate. There's no distribution to anyone. It is a charity, and it is a registered charity. It is governed by the requirements of the ACNC, and it's a trust, so also the trustees have fiduciary duties. So it's already fairly heavily regulated, is my point, to ensure that it discharges its functions and it uses its money to the best interest of the agricultural community. So there's a question in my mind as to whether or not it should be caught by these changes, but it is. So we think that it's important that we also make representations about how the defendants might take advantage of court proceedings to frustrate and thwart the interests of the plaintiffs.
Okay, thank you very much, Mr. Rogers. Mr. Panetta, did you have anything you wanted to add by way of opening statement?
No, nothing further to add. That basically.
Okay, thank you. All right, Senator McDonald, you have the call.
Thank you very much, Chair, and good afternoon to you all. Happy New Year and welcome back to the year. Mr. Marland, could I start with you? Specifically, you have a class action happening at the moment for landholders and farmers around Paradise Dam, I understand. Just specifically, how would these changes in legislation affect the ability to fund and run that particular class action?
Thank you, Senator McDonald, for your question. The size of our action, and given the quantum that potentially could be claimed, depending on differing factors, will mean it probably won't be directly impacted. It's really class actions that are probably less than $100 million. Now, I know that sounds like a lot of money, but when you're running large-scale litigation actions, $100 million is basically the funding ratio to success is significantly diminished. Now, but one of the things we face with Paradise Dam is that it's an evolving class action. So it's not like a bushfire or a flood. It is an impact that is continuing because the water security, it won't be effectively restored until the dam's fixed and the dam's full. So losses could be 100 million, they could be $1 billion. And there is literally a range of that. And so getting the action actually off the ground, and we're in active negotiation with several litigation funders. And when this bill was proposed, the timeframe and process that we've had to go through has delayed our action by over 6 months. We've had to go through a whole nother range of due diligence and commercial calculations, from increased book bills to experts' reports. And we've been fortunate in our action that it's funded from growers. And so we raised $1.2 million to help seed fund this action. And $1 million sounds like a lot of money too, but I'll tell you what, when you have a few GCs and barristers and experts, it gets chewed up very quickly. And so that has come at the direct cost of the farmers, because we could have filed this action in June if we had had a funder, because the action was and the advices were received from our barristers and experts. So it's very frustrating. And the reality of it is with dealing with litigation funders, and I say this to my plaintiff groups as well, it's not like going to the bank and asking for them to lend you $10 or $15 million, because you usually got security and you've got something that you can put behind it. A class action is effectively going with a business plan. And so they're putting significant capital up as risk, but also funding adverse cost insurance, which is significant liability for plaintiff groups. And they go through a due diligence process in themselves. So a lot of class actions effectively aren't run if they can't be funded, and two, that they're not a sound case to be funded by. So there is a hell of a lot of work that goes into it. I've spent the last 18 months developing this class action. We've been fortunate the government have made a decision to fix the dam, but the losses are still accruing and the risk is still there, but we still don't have a class action funded.
So what I'm trying to understand is that, where is the potential impact to the class action industry, if I call it that? Are we going to end up, would this legislation result in big class actions being more easily able to be funded and run than a smaller, as you say, $100 million action? Is that what we're going to end up with kind of the big end of town in class actions being able to proceed, but the smaller, more niche class actions potentially being at risk?
100%. There'll be just class actions won't be run, particularly under $100 million. And that directly reduces access to justice. There's no other way around it. And this bill is intent, while it might be well-intentioned, the perverse outcome of it, that's what will happen. Less class actions will be run, less access to justice will be made available to mum and dads who are wronged by a corporation or a government. And to cap that process and to cut out an avenue of recourse, I think that is the most insidious part of this bill.
Mr. Rogers, if I could turn to you and just ask you a similar, question. The National Farmers Federation Fighting Fund has been designed to be a funder for class actions like the live cattle export shutdown, and no doubt others. What do you see the impact of these legislative changes being in your environment?
So just to clarify, Senator, the AFFF, Australian Farmers Fighting Fund, does fund a lot of litigation. A very small portion of it is actually class action matters, and as I said, there's only been one to date. So we have not a huge interest in this area. I don't think this, if I'm brutally frank, I don't think this legislation would make much difference to us, because I think most of what we do is already compliant with the requirements of the legislation. And when I say we are, obviously I mean the AFFF, which is the trustees. And the commercial return is not a huge consideration. It's almost it's a way to fund, and it's a way to maintain the existence of the AFFF and to fund future matters, but it's not necessarily going to have an impact on the decision-making process. It's one of maybe five, and probably the fifth of those five of the considerations that the trustees would take into account. So I don't think it would have a major, I'm honestly being quite honest in saying I don't think it would have a major impact on the AFFF and the AFFF's operations. That said, the sorts of concerns that Mr. Marland, and I would defer to people who understand it better than me, I'm not a class action lawyer, I'm just a secretary for the AFFF, but the sort of impact that Mr. Marland is alluding to would be a great concern, I think, to the farming community more generally, and the NFF more generally.
So one of the things that Mr. Marland raised was this issue of moving to state-run jurisdiction actions as opposed to a federal oversight. So, you know, just the one class action then that the Australian Farmers Federation, the Fighting Fund, has covered, I mean, that was multi-jurisdictions, being WA, Northern Territory and Queensland. I don't think there was others from other states, but I might be wrong. I mean, would that, I assume that in that one case, that would then be problematic. You would have had to have run multiple actions across multiple jurisdictions. Does that sound reasonable?
It sounds reasonable. I'm not quite sure about those sort of jurisdictional issues. I mean, it was federal legislation, so I don't know if they could be contemplated at the state courts. It was a decision of the federal minister. So I'm not really quite sure how it would operate, but yeah, that would be a concern. And it was a there were claimants from different jurisdictions. And so to the extent that would mean that different actions would have to be started in those different jurisdictions, that would definitely be a concern to us, yes. We are a national organisation. The AFFF is a national organisation. So limiting actions to states is, to be frank, one of the considerations for the trustees is whether or not the litigation is going to have an impact nationally as opposed to just being a discrete region.
Yeah. Chair, if I may just have one final question. I know that you have other senators who want to ask questions. Mr. Marland, so can I just understand, in the environment that you're in, of seeing class actions on a smaller scale, what would happen to those smaller class actions? Where would they go for funding? Or would there just be no opportunity at all? Just explain that to me.
The thing you've got to remember is with litigation funders, there's not a hell of a lot of them. It's a very niche financial service. And they just don't have hundreds of millions of dollars sitting in a bank account waiting to fund an action. And it's not a matter of them sitting there saying, oh, we want to get 30% or we want to get 60% or we get 10%. They look at the investment like any other business does it. They look at the investment of their capital and what the risks are and what their returns are. And if the returns, if the risk outweighs the return, they just don't fund it. They go and put that money into something else. So you'll see where, you know, there's some very large litigation funders here in Australia and some very small ones. You'll see a restriction in the market, and you'll see funders just disappear from the market, and that will automatically either mean that the big players swallow up all the cases, or actions are just not run. It's as simple as that. I can't see any other outcome than that occurring if this bill is passed in its current form.
So you'd end up with the big multinational players dominating the what class actions went ahead in this country because of those smaller tier 2, tier 3 law firms and associated funders not being able to take class actions forward.
Or take their work somewhere else, go overseas to more favourable jurisdictions. It's as simple as that. And that's the funders will find another way to invest their capital, whether it's in a reduced class action or big class action or something completely different. But the people who are missing out are those who live in the Australian jurisdiction, need class actions as a form of recourse against damages and wrongs that are caused in those processes. And so that's, the funders won't particularly lose out. It'll be people of Australia.
Thank you very much, Mr. Marland and Mr. Rogers. Thanks, Chair.
Thank you, Senator McDonald. Senator Chisholm, you have the call.
Thanks, Chair. Senator McDonald did cover off on a lot of the questions or themes that I was going to ask about, but I did have a couple, and I'll try and be brief because I know we need to stick to time as well. Mr. Marland, I'm aware of your class action up in Bundaberg, and I've been following that reasonably closely. I was just interested in, I suppose there's a range of sensible measures the government could have included in the bill that would actually improve outcomes for plaintiffs. In your submission, you refer to a comprehensive report by the Law Reform Commission, which the government commissioned and then ignored. Could you elaborate on why you think the recommendations in that report would be a preferable way of improving outcomes for plaintiffs in class actions, while also ensuring that the litigation of funders and class action lawyers are properly oversighted?
Thank you, Senator Chisholm, and that's a really insightful question. I guess the law reform report, it dealt with a broad range of stakeholders, from plaintiff lawyers, defendants, companies, litigation funders, broad range of segments of the community. And I think the overall feedback is that there should be regulatory oversight where that generates better outcomes for access to justice and plaintiffs. And it was a very informed process by people who actually know how to run class actions and how class actions are actually operated. I mean, one of the things that frustrates me, and I say that honestly, it frustrates me with this bill, is the people who are best placed to determine whether a case is, whether a plaintiff lawyer is overcharging or being unreasonable is the judges, is the federal court judges, who see this day in, day out. They see the conduct of both parties, they see the complexity of the parties, and we've already seen the federal court judges being more instrumental in ensuring that costs aren't overcharged or excessive. And there's been a number of cases recently where the judges have stepped in and not granted the costs as claimed by plaintiff lawyers. So we're already seeing that. Now, with the recommendations for the Australian Law Commission was very considered. The input was from people who knew what they were talking about. And it would have actually, if you look at those recommendations, I don't think you would have seen a great deal of dissent against, if those recommendations were in the bill, I think you would have seen broad scale support across the entire industry. But what this bill does, it even overturns some of those recommendations. Just the example is open class actions. That is the most efficient and easiest way to run a class action. And that was one of the main recommendations out of the Commission report. And this bill directly prohibits it or restricts it. And I guess we've got to go back to, you need to be listening to the people who actually know what they're talking about. And that's the people who actually regulate and run class actions. And that's what the Commission report did. This bill completely ignores that process.
Thanks, Mr. Marland. So the government seems fairly determined to proceed and get this bill passed. There's obviously a fair bit of opposition to the bill, and indeed, when it went through the House of Representatives, there's at least one of the LNP members crossed the floor. Can you explain, why do you think the government is so determined to get this legislation passed, despite there being all these concerns raised and some of the issues that you've highlighted today?
Look, I think genuinely they do. We've seen in the papers when there's been some recent class actions like the Banksia Securities class action, which made the front page of the Australian, and the community is generally concerned about class actions and potential for litigation funders to be making obscene profits. But when you dig down into the detail and you actually look at the process, it's not the case, and it's already being regulated and managed. So I think the government have taken a view that it's in the best interests to ensure that class actions and litigation funding is better managed. But I don't think they've listened to the right people. They haven't spoken to the people who have practical knowledge. And this is not just from people like myself. I'm talking about federal court judges who have dedicated their entire lives to the legal system and run these class actions on a daily basis. And those are the people you need to be listening to. And I think this bill, while it might be, the intent was good, I think the unintended consequences haven't been thought through and will end up as a detriment to your mums and dads out there who don't have financial recourse to go up against a bank who's incorrectly charged them interest over the last 5 years. It just doesn't happen. And that's the main problem with this bill.
Thanks, Mr. Marlin. This should be my final question, and I'll put it to the NFF. Which part of this bill, if any, do you think will actually improve outcomes for plaintiffs in class actions? Based on what I've looked at from the Joint Committee report and also the submissions to this, I don't think we've received any real evidence whatsoever that's likely to do any such thing. In fact, the previous committee that looked into this bill, the overwhelming evidence was that the opposite was true, that this bill actually harms plaintiffs by making class actions more expensive and often financially unviable in the first place. So is there anything the NFF can point to that will actually improve outcomes for plaintiffs in class actions?
Well, I mean, I think it stands to reason that more scrutiny and oversight of these arrangements by an objective and well-informed decision maker, and that objective and well-informed decision maker, the judge, having access to the reports of experts is going to have a good outcome for plaintiffs. Caps on the returns to the litigation funders of 30%. And that's only a sort of a base position. It's a rebuttable presumption. So where the funder needs to claim more and can make the argument, then presumably they would have that opportunity. So I mean, I'm only speculating here, Senator, but I mean, on the face of it, those sorts of things seem to me that they would have a net positive impact, or could have a net positive impact for plaintiffs.
Thanks, Chair.
Thank you, Senator Chisholms. I think, Senator Patrick, you said you'd be happy to go last. I just wanted to ask a few questions and before I go to you, Senator Patrick, to finish up, if we could. And I really want to delve into this issue of the conduct of defendants, of large defendants. And this formed a large part of the National Farmers Federation submission, and Mr. Marland also referred to it. And the title of the bill, which we're considering, is Improving Outcomes for Litigation Funding Participants. And it seems to me, Mr. Rogers, that when you reflect on the live export case and how that was conducted by the defendant in that case, which was the Commonwealth Government, which is subject to model litigant rules, and there are other large defendants which aren't subject to those rules, the way that case was conducted in a number of respects did not improve outcomes for the members of the class action. I'm wondering if you can provide an overview of the concerns the National Farmers Federation had with respect to how that case progressed in practice and the impact of the delays, obfuscation, the impact of that on the members of the actual class who were seeking compensation in that case.
So the key issues there for us, Senator, were the fact that the litigation, which is still ongoing to this day, was commenced back in 2014 and it is actually still on foot. We got a decision on liability in 2020, so 6 years to get a decision on liability. And the intel that we were getting from the solicitors who were acting on behalf of the claimants was that the defendant, the Commonwealth Government, dragged their feet at every opportunity. And particularly egregious was the way that they dealt with discovery, which took around about 4 years to complete. There were 22, I think, tranches of documents. They just would not give everything. We had to go back and ask again.
So Mr. Rogers, just explain that. No, I'm a lawyer by profession. I've been involved in some large litigation claims. The way discovery should work is you provide the documents which are relevant to the cause of action. Each side swaps documents, and maybe there's there needs to be some tidying up. There's a few disputes or issues that might arise as to whether or not something's relevant, whether or not something is privileged, and you've got to resolve those. But there were 20 in the live export case. There were 22 tranches of documents. Just explain what that means in practice and the delay that causes in practice.
Well, so my understanding is that the Commonwealth made discovery, and the lawyers had a look at the document and said, well, that's clearly not everything, and there's a reference to another document here, or this other document needs to be produced. So yeah, I couldn't express it better than you have, which is a process which should be relatively well, it shouldn't take too long, a couple of months maybe, because of the way that the Commonwealth approached it. It took 4 years, and this, admittedly, this would fall on one of the more complex ends of, there would be a lot more tidying up with this matter because of the complexity of the legal arguments, and we're dealing with the Commonwealth government and the privilege issues and so on and so forth. So admittedly, this would be one of the more complex discovery procedures, but 4 years is just out of this world. 22 tranches of documents, just out of this world.
But
and there's
isn't it the case that the way the system should work, and I might seek Mr. Marlin's view on this, that an action like this, where class members are constituted by very vulnerable members of our community, in many cases, they've suffered in the case of the live export case, and Mr. Marlin's acting in two class actions. The members of the class have suffered loss. In some cases, they can be in desperate economic straits. Their resources can be limited. And when I say resources, I include their emotional resilience and capacity to withstand all the stresses involved in terms of the litigation. Shouldn't the way the process works, shouldn't it be that the issues are debated, they're ventilated, they're decided upon in the most efficient, practical way possible to get a final resolution for the benefit of all parties involved? Isn't that the way the system should work?
Sorry, so was that for Mr. Marlin or myself?
Oh, it's for both of you. So,
I mean, I would say yes, if Mr. Marlin can add to that.
Yes, in a perfect world, yes, Senator, but the practical reality in the cut and thrust of high pressure litigation, I guess parties do whatever they need to do to preserve their own position, and unfortunately, delay and obfuscation is one tactic. And judges do try to corral, I'll use that as one of a better word, to ensure the efficiency of that process. But when you're dealing with, and I'd assume that NFF with the live export class action, there would have been hundreds of thousands of documents. And I've been through that process myself in litigation. And, you don't want to say the other side isn't acting in good faith, but, in that NFF case, if there's 22 cases or tranches of documents, you have to go back to the court to get that, clearly indicates the defendant is not acting in good faith. And I guess that's what my main problem with this bill is it will continue to, it actually incentivises the defendant to act in those ways, because it just burns, like, I don't know how much that would cost. I mean, every time you brief a barrister, you've got to go 22 times, you've got to go back to court, you've got to prepare, you've got to go. It's a very expensive process. So I'd assume that process would have been in the order of a couple of $1 million alone just to get the documents. And if you put a cap on the plaintiff's ability to fund that, well, the defendant simply says, we'll just run them out, we'll run the clock out until they reach that cap, and then suddenly there's no more money left. And that forces a plaintiff into a situation to effectively either not run an action, or have to drop an action, or reach a settlement that's not optimal for the plaintiff group.
So, Mr. Marlin, the NFF proposes some procedural amendments or changes to process, and there are recommendations there in relation to security for costs applications, controlling strikeout applications against each of the parties pleading, so they don't go on interminably. Parties required to conduct at least 2 court-ordered mediations, limiting costs which may be claimed by respondents to subpoenas, lay witnesses and the preparation of their evidence, representation of court appearances being limited within reason. So you don't have a battery of QCs all representing the one side, and prohibit respondents from pressuring group members. Have you had a chance to have a look at those? And do you have a view on those procedural proposals from a legal practitioner's point of view as dealing in this space?
Yeah, look, I did look at those recommendations, and they all make sense. I guess I just took the view that you're already seeing those types of case management procedures being implemented, particularly in the federal court, and particularly in the class action regime, where they are actually trying to improve that process. And you see also the state levels where they are bringing in those case management procedures and court conference rules that do assist in the efficiency of it. And I guess there's always more work that can be done. I guess I'd always do take a view that each case is different and needs to be managed differently. And I guess my view of it, and I spend a large majority of my time in courts, is the best people placed to manage that process is the judges, and we need to be providing them with as much flexibility and resources to enable these cases to be run more efficiently. And I guess one of my concerns with this particular bill is it's actually taking away the powers from the judges to run cases more efficiently.
Okay. Senator Patrick, thank you for being so patient. Mr. Marlin, you should be aware that Senator Patrick is one of the best lawyers in the Senate, even though he doesn't have a legal degree. So I'll pass over to you, Senator Patrick.
I think it's formally bush lawyer, I think is the formal term. Yeah, look, I just wanted to get a bit of an understanding of the types of people engaged in litigation or in matters that involve class actions. Obviously, we saw on the weekend Mr. Dokovic clearly had means to bring a legal action, but perhaps wasn't seeking a financial remedy. I presume in your case, you have some issue that arises. Is there some minimum number of people? Is there some minimum number of or number in terms of cost remedy? What's the formula? How does that work? And how does this legislation disrupt that?
Well, effectively, class action, effectively, all you need is 7 to run it in that registry, and so that's federal court registry. I think Queensland jurisdiction's 7 as well, so it's a minimum number. And that's just to assist with efficiencies. But you can imagine, let's say, for instance, the Brisbane floods class action that was run, took 10 years. First order was 600 million in damages. I think there was something like 3,600 plaintiffs. If each of those plaintiffs were required to fund that action against the state government and Sunwater, I think the legal costs come to about 140 million or 127 million or something like that. I mean, it's just an individual couldn't do it, and that's the whole point of class actions, is that you can group plaintiffs with a common cause of action together. You can fund it, you can run it more efficiently, and I guess as well, when class actions are determined, so you determine liability, and then you determine quantum and damages. And so that process is overseen by the courts, and that's a far more efficient process. So if you actually look at it if you just look at it from a theoretical point of view, it's far better to run one big case than it is to run multiples or thousands of smaller cases. And I guess the practical side of it is if you're forcing plaintiffs to run individual cases, they're just not going to run them. It's as simple as that.
Sure. So it's clear that you have a number of participants in the class action. It's clear there's some financial remedy at the end of it, of which is used to fund the legal costs. But there's some point where you get, in formulating this up, I presume that maybe it starts off by someone coming on with a complaint, and I presume the lawyers may well suggest, because the complaint is of a nature that it would affect many people, maybe they suggest a class action, or is it the class action experts that identify a problem and then generate the plaintiffs? Is that how it works?
Well, look, each case is a little bit different, but I mean, let's say, for instance, Paradise Dam, everyone had 600 farmers had the same problem. Dam was faulty. Each of those farmers could run a separate action for liability against the government. They quickly grouped together through their relative, organisations, and then suddenly a class action's formulated. They go away and get some advice from a lawyer and speak to a barrister and talk to some experts, and suddenly you look at the efficiency of it and say, well, the best way to run it is a group action. Then you see little things like, we see a lot of class actions for very small transactions, like credit cards that have been overcharged, that, a plaintiff might have only lost $1,000, but there might be 10,000 of them. So for that one person to run the case to get back his $1,000, he's going to spend 10,000 to get back 1,000. It's not going to happen. So then you start to see where there's some common processes that roll out. And so what happens with, class action law firms, you'll see it. They'll have a client that comes in and has got an issue, and then they'll go around and see if there's other people who've got the same problem. And that's how class actions are formulated.
And in terms of the way in which a class action is accepted by the lawyers, my understanding is that if there is a cap, then there'll only be appetite for the more likely wins. And can you sort of give me some assurance that left the way it is, there is that risk appetite does vary as a function of, and I presume that there are cases where you lose, and therefore you lose your costs and perhaps have to pay them out. And then there are other cases where you win and you kind of amortize out the losses and the gains. Is that kind of how it works, or is it just a case? And if there's legislation comes into place, are we just going to people say, no, I'm only going to chase the ones where there's a really good chance of winning?
Look, I guess, no case is a lay down misère. Every case is, you see it all the time in courts. It's always, 50-50. So no case is certainly some cases are stronger than others. But there's a lot of work that goes into building up cases, and a lot of that work's done once they're funded and worked up. So the funders pay the solicitors to basically develop the case, and they go and get experts to provide the evidence. So it's not a case that necessarily that a funder or a lawyer looks at the case and go, oh, that one's a winner, because sometimes when you start a case, it ends up in a completely different place than when you started. And there's a hell of a lot of work that goes through that process. And so funders, I mean, the thing we hear a lot about when funders win, you don't hear a lot when funders lose. And they lose a hell of a lot of cases, and they're very expensive. And the other thing too that funders, a really important role that I think gets missed in all this, is they pay for adverse cost insurance. So what that means is if you're a plaintiff and you're running a case against a bank or a government and you lose, they're not going to take your house getting cost back out of it. So the funder actually indemnifies the plaintiff, so they're effectively at no risk. And so that's the money that the funders put up to help run these cases. So it's as of least amount of to least impact to the plaintiffs as possible. And if you put a cap on those costs and you put an arbitrary commercial limit on it, you'll just simply say cases won't be run. It's as simple as that.
Senator Patrick, we've come to the end of time for these witnesses, and Senator O'Neill has a few questions she would like to ask. Have you got one final question?
Yeah, one more. I might split it into two, and that is then firstly, my understanding is that already there are in place mechanisms by which the court will make sure people are not being ripped off. Well, I just wanted to maybe just explore that. In terms of this legislation, which I presume is designed to the motivation for the government is to, well, I'm guessing to reduce the amount of larger companies that are sued and the actions against themselves. But they might purport to be looking after the plaintiffs by way of making sure that the lawyers don't take all of the money. What processes are in place now without this legislation to protect plaintiffs from that sort of gouging or a non-return in effect even if they win?
Well, I guess the first thing is every solicitor in Australia is guided by rules of misconduct. So, if it doesn't matter if it's a class action or a house conveyance, if someone thinks they're being overcharged by a solicitor, there's review processes for that. In the federal court, we've seen only a couple of years ago that there was a decision called Money Max, where Justice Murphy looked at the orders for all the applications for costs for both the funder and the lawyers and knocked it back and said it was unreasonable. So we're already seeing judges looking out for the best interests of the plaintiffs. And this is one of the main points I make is that people who are in the best position to determine what's fair and reasonable are the judges. With all due respect, not the politicians who, no disrespect again, don't always know what they're talking about. We've also recently seen in the Victorian jurisdiction where there was the Banksia securities case where the judge was scathing in his decision and actually referred the solicitor and the barrister for disciplinary proceedings, and both were struck off. So every solicitor knows that there is a very real risk if you overcharge, the courts will pull you up and you'll be struck off. And there's already extensive processes for that. And I guess sometimes you look at a case and say, oh, that's an extraordinary amount of money, but you've got to really understand on how complex some of these cases are to run. The live export class action, for instance, 10 years, or 10 years to run, or 6 years to run, still going. QCs and barristers and experts, all that adds up. And what the government is currently asking is that all remains within the 30%. And sometimes it can, sometimes it can't. But by putting an arbitrary limit on something without taking into consideration the complexity and the size of the action is taking away discretions of the court, and actually it's an impediment to access to justice.
Oh, thank you. Thank you, Chair.
Senator O'Neill.
Thank you, Chair. If I could just follow up a couple of the points raised by Senator Patrick there. We know from your submission, Mr. Marland, that you have looked at what the Australian Law Reform Commission recommended, and you've noted in your submission helpfully parts that have not been addressed in the way that this bill has been drafted. Mr. Rogers, you made a very eloquent bid for this legislation really not to go ahead, because if it does, you believe it will give less access to justice for mums and dads who are wronged. 30% of not being able to go to court is zero. That's really the likely outcome for very many people who will now be denied access to justice. So I invite both of you, if you could expand on the opt-in, opt-out element that's in the piece of legislation currently. If you're aware of sufficient detail, could you refer to the Parliamentary Joint Committee Corporations and Financial Services recommendation that there should be the word only removed from the way in which judges should be able to interpret the costs, the benefits and the detriments. So I invite you both to sort of respond to access to justice, opt-in, opt-out, and the arbitrary 30%, which sounds like a saleable idea, but in fact really isn't. So, yeah, your thoughts about those things. Thank you. Mr. Marland, do you want to kick us off?
Well, look, an opt-in, opt-out process is effectively, so you can start a class action and it's an open class action. And through the development of the class action, you can either close it or leave it open. It's the discretion of the court and depends on the type of matter. So if you've got, as I said before, if you've got a credit card class action where there might be 100,000 plaintiffs, by asking the lawyer and the funder to go and sign up individually every one of them before they can run the class action is prohibitive.
So it means that cases that really have merit would never be run and particularly deny access to people who have the least knowledge of the law. I mean, we've talked about the farmers who got together in the case that you're working on. You know, farmers are very sophisticated businessmen and women who know how to, you know, handle contracts, law and transactions, and they have a high degree of literacy. And even with that, you're saying that there are challenges. So for ordinary people who might not have any knowledge of the law, what does opt-in mean for them?
So an opt-in means that they have to physically sign a retainer with that class action, and that class action can't proceed until there's a certain, basically once it's closed, it's finished. And so what happens with a lot of class actions is they develop over time. So, you know, and they might take a number of years to develop. So you leave it open so you can get as many plaintiffs on board as you possibly can.
And you efficiently then prosecute it once. And I think the Law Council indicated they're concerned that this bill, as it's constructed, will likely encourage significant satellite litigation over the proposed provisions. And they're concerned about the constitutional validity and interpretation and effect of those laws. Do you have a view about that?
100%. I think what would happen, let's say, I'll just use an example of credit card class action. There'd just be a class action filed in every state because it would be, well, I mean, I'm interested to see how the government proposed to override constitutional issue of this bill, but you'll start to see multiple class actions run on the exact same point. And so that's
which is uncertain for businesses as well.
100%.
Right, so it's bad for the plaintiffs and it's bad for corporations as well.
I think in the long run, yes. And I mean, look, at the end of the day, if corporations are doing the right thing, if governments are doing the right thing, you wouldn't have class actions, but you do.
Yes. Well, we always want to strive for the ideal, but the main thing I think with this bill is to make sure that the Parliament is aware of how bad this piece of drafted legislation is and the very long-term significant impacts of denial of access to justice if it's passed as it stands. Mr. Rogers, do you want to provide a response to the points that I've raised?
Oh, just in terms of the opt-in, opt-out considerations, I would agree with Mr. Marland. And just to use the LiveX as a good example, the class is actually still open. So the matter commenced in 2014. It's been going for 6 years. The class is actually still open and people are still joining. There's people.
Why are they so slow to join, Mr. Rogers? Because this is something I think the Senate needs to understand. Why are people slow to join these?
Because my understanding, and I'm generalising, is that it was a traumatic experience, and they don't want to join. They don't want to revisit it. And there were. This is to go to a question that was raised by Senator Scarr, which I sadly didn't get an opportunity to answer. But it was a traumatic experience. The closure was a traumatic experience. The litigation itself has been a traumatic experience. These are people who have suffered massive personal, not just financial loss, but massive personal loss. And there are reports of, divorces, families breaking up, businesses closing down, and even sadly suicide as a response, directly or indirectly in relation to the decision of the government and the way the litigation was run. So they're traumatized by the experience. They don't want to revisit it. They don't want to open up old wounds. They just want to be able to move on with their lives. And so that's massively to their detriment, ultimately. So having to close the class effectively before proceedings are commenced, would have a really detrimental impact upon those people and on the little guys.
So as the bill stands, gentlemen, it's been highly contentious in the House of Representatives. There was a very split decision by the Corporations and Financial Services Committee. Labor opposes the bill completely as it stands. There was one change that was recommended by the Liberal controlled party, the government controlled committee. And the recommendations that you highlight from the ALRC are nowhere to be seen in this piece of legislation. Given what you've said today, and that's a very brief overview of where we are with this legislation, what is your recommendation to the government, members of the Senate, and to the crossbench who are represented here, perhaps? I'm sure Senator Patrick will be talking to the others. What's your advice, Mr. Marland, and then Mr. Rogers?
Scrap. It's completely unworkable. It's detrimental to those that need the protections. And you've already got a platform and really sensible recommendations that are actually workable from the Australian Law Commission report. I would
So it
suspect-
deserves a better piece of legislation.
100%. And I don't think you would see, if you adopted all of those recommendations from the Law Commission and put that into the bill, I don't think you'd see pretty much any dissent.
Thank
And
you,
I think
Mr. Marlin. Mr. Rogers?
I mean, I don't think I would disagree with Mr. Marlin there, but we have made recommendations on what we think would be suitable changes to the legislation in terms of safeguards. If the government's fed income about ensuring the outcomes for participants in class action litigation, then there should also be some consideration about the way that the defendants handle themselves and what they need to do to worsen that outcome.
It's a pretty interesting point to ask, is the government fed income? Anyway, I thank you very much for the opportunity to ask the questions, Chair. Thanks to the witnesses.
Thank you, Senator O'Neill. And Mr. Rogers, I feel somewhat guilty that I did cut you off at some stage in terms of answering the question I put, but I do appreciate you taking the opportunity through Senator O'Neill's questioning. And just to give maybe you the final word on this, is it correct to say, and this is all about protecting the interests of members of a class, the people who are subject to a wrong and are seeking redress through our justice system, is it fair to say that in the live export case, the process itself, which followed the initial wrong, had the impact on Australians, people we're representing, of traumatising them? The process itself was traumatic. Is that a fair comment?
That's a fair comment. It was a traumatic process, and it had really severe consequences for them. Okay.
All right. Thank you. Thank you very much, Mr. Rogers and Mr. Marland and Mr. Panetta. Thank you for joining us today, and we really do appreciate the time and effort which you put into your submissions and your testimony here today. It's very much appreciated. Thank you very much. So I'd ask you to disconnect from the video conference if you do want to continue watching. We've got the Law Council of Australia coming up next, so feel free to use PowerView to do that. I now welcome the representative from the Law Council of Australia, Mr. Emerick. Thank you for appearing before the committee today. And I'll just wait till see you. So we have Mr. Farrell, I can see. Mr. Emerick, thank you for appearing before the committee today. I'm sure if you're listening, you're probably quite content to let Mr. Marlin continue to provide testimony in that regard, which was most useful. I invite you to make a brief opening statement, should you wish to do so. For the Hansard record, could you please state your name and the capacity in which you appear? You're just on mute, Mr. Emerick.
While John's sorting his audio out, I may as well do my name. So John Farrell, Senior Policy Lawyer at the Law Council of Australia.
Okay. Can't hear you, Mr. Emerick. I can't hear you. I'm not sure if Secretariat can. We did have a problem earlier today.
Is that better now?
That's perfect.
Okay, great. Thank you. So, John Emerick, I'm the co-chair of the Class Actions Committee of the Federal Litigation and Dispute Resolution section of the Law Council.
Would you like to make an opening statement?
Yes, we have a brief opening statement. So the Law Council welcomes the opportunity to appear today before the committee. I'm appearing today with John Farrell, who's a senior policy lawyer with the Law Council. The Law Council strongly supports a class action regime that effectively promotes access to justice. It also supports a policy goal of improving outcomes for class action members by ensuring that they receive a share of the claim of the proceeds, which is fair and reasonable. As the Law Council has observed in its submissions in relation to the bill, the courts already have powers to oversee and control legal and funding fees in class actions. It's a robust, independent framework of powers and discretions to protect the in-group members, but it can be improved. Additional oversight by the courts to ensure fair and reasonable outcomes should be considered as the preferable forward. The Law Council considers that clarifying and widening the powers of the courts and promoting competition among funders is the best way to protect group members. The likely effect of additional regulation is, in this context, going to stifle competition to create uncertainty and additional cost for class action members and respondents alike, and to reduce the availability of funding for some meritorious claims. So to that end, the bill appears ill-suited to achieving its laudable goal, and the reforms proposed by the bill are, we have observed, particularly complex. Our assessment is that they are likely to give rise in practice to a range of unintended consequences to the detriment of both group members and respondents, as well as the public interest. And as identified in our submission, there are significant constitutional law concerns that we've raised in relation to the bill. The Law Council notes that this committee has sought information from the Attorney General's Department regarding the heads of power, or the head of power or heads of power the bill is that it relies on to support the bill. The Law Council considers it's important that the Parliament is aware of the constitutional head of power relevant to the legislation sought to be enacted. It's relatively common for the head of power underpinning legislation to be disclosed, and it's the Law Council's view that such information can be provided without breaking client legal privilege or public interest immunity. So in the Law Council's view, the bill should not proceed in its current form. Rather, it should be the subject of a comprehensive consultation with stakeholders to ensure the reform of the regulation of litigation funding can meet its intended purpose, or the intended purpose of the bill, without impacting on access to justice and creating uncertainty and costs to the detriment of claimants and respondents alike. Thank you, Chair and committee members. We are happy to answer any questions.
Thank you very much. Senator Chisholm, do you have some questions?
I do, thanks, Chair.
You have the call.
Okay, thanks. I just wanted to focus in on you may be aware that the majority of Liberal members on the Parliamentary Joint Committee on Corporations and Financial Services, including the Chair, recommended that the word only be deleted from section 601 LG3 to ensure
yes.
that, the Law Council, including you, Mr. Emmerich, went to a lot of trouble preparing a submission for and giving evidence to the Parliamentary Committee. And you and other submitters to that committee's inquiry managed to persuade the entire committee that the word only should be deleted. From your perspective, how disappointing is it that the government has not done that Parliamentary Committee or the submitters to the committee the courtesy of responding to that committee's report or that particular recommendation?
Look, I think I'd just simply say this, that we regard the deletion of the word only as a matter of great significance, and we consider it would be a significant error of judgment if the legislation was to proceed with that word to be included. We think that would be adverse to the interests of the participants in the class action regime, and specifically to the class members who ultimately have to have their interests determined by the court. So that'd be the way I'd answer that question.
Okay. Could you explain the significance of?
The main problem with, there are a couple of problems, but the main problems are these. The first is the use of the word only curtails the exercise of discretion by the court in relation to determining what are the relevant factors in approving a settlement resolution and distribution.
So, sorry, Chair, can I just ask, can you just point me to the section of the legislation that we're referring to? Quite interested in this. I'm just trying to follow it.
Section 601 LG brackets 3.
Thank you very much, Senator Chisholm.
And so that the first is the curtailing of the discretion by the court. I mean, the courts have always been relied on to exercise their judgment in relation to what is just and fair and reasonable. So it's a very uncommon formula, particularly for civil litigation. And it runs the risk of, in a particular case, a court not being able to do justice in the matter, taking into account what might be the specific circumstances of the case. And I think I've been practicing in class action litigation for nearly 30 years now, and in litigation more broadly for 33, 34 years. And the one thing I've learned is that you could never really predict all of the circumstances of a piece of litigation. There may be particularly unusual circumstances that arise that make it relevant to consider factors beyond those that are listed in that test. For example, the solvency of the plaintiff or the risk of insolvency, the presence of insurance. There's a bunch of other factors, and I think the difficulty here is just proscribing the court's ability to consider a broader range of factors, bearing in mind the expertise available and the implications. So the word only goes. If the word only goes, then you can certainly prescribe factors the court should take into account, but it also therefore leaves a discretion for the court to take into account other matters that are relevant to that particular piece of litigation.
Mr. Emery, you gave evidence to the Parliamentary Joint Committee in November last year.
Yes.
Is there any aspect of the bill that you've changed your opinion on since then?
No.
Okay. On that day, you told the Parliamentary Joint Committee that the measures in this bill are likely to give rise in practice to a range of unintended consequences to the detriment of both group members and respondents, as well as the public interest. Do you stand by that evidence?
Yes.
Okay. You also told the Joint Committee that the bill will likely encourage significant satellite litigation over the proposed provisions and their constitutional validity, interpretation and effect. Do you stand by that evidence?
Yes, I do. There are some examples given in clause 11 of our submission for ease of reference later on.
Okay. And you also said that the bill would increase costs, reduce efficiency, and make settlement more difficult and uncertain for all parties to class actions. Do you stand by that evidence?
Yes.
Okay. Are there any other concerns that you would like to put on the record about this bill?
No, I think we've dealt with them, I think, comprehensively through the combination of our written submissions and our prior evidence. And at the risk of repeating myself, for me, the challenging aspect for legislators in considering this matter is this balancing act. We all, I think, understand that the goal of seeking to get more money for class members, it's clearly a desirable goal. But the difficulty in setting this benchmark of 70-30, it's going to mean that meritorious class actions are not going to be funded because that goal will be very hard to achieve or creates too much risk for funders and others who would support that litigation. And if the studies are right, and that means something like 3 or 4 out of 10 class actions that would currently run will not run, and particularly this is in the low value area, then the policy choice is this: do you try and guarantee something around 70% for the class actions that do run and say too bad for those who can't run the class action, or do you do what's currently on offer, leave it to the courts, taking into account the merits of the case and all of the factors relevant to approve, to override and approve settlements and reject those ones that are not sufficiently persuasive, and leave the court to do their job, so to speak. For me and for the Law Council, the balance is we think it's better that all meritorious claims are given a chance to run if they can, not just those lesser few. And we think the 70-30 impediment, while it is clearly designed, and I think the earlier witness may have said this, at face value it has an attraction. I mean, it's clearly designed to try and achieve a good goal, but it's going to cause more problems than it's going to solve in seeking to do so. So it's well intended. We appreciate that, but it's just in practical terms not going to achieve a good outcome for a large number of people.
Thanks, Chair.
Thank you, Senator Chisholm. Mr. Emery and Senator Chisholm referred to this point that I served on the Parliamentary Joint Committee which considered the issue, and it's good to see you again. Happy New Year.
Yes, very cool. You too.
And Senator O'Neill also participated in a lot of that those hearings. We've talked about the issue with respect to the word only. Can I ask you this question? So obviously, the intention of the Joint Parliamentary Committee with that recommendation to delete the word only was to ensure that the discretion of the court's not fettered in terms of the relevant matters it should take into account. And certainly one of the concerns I had in my mind was the legislature can try and anticipate what it should or shouldn't take into account, but at the end of the day, we have a process where we have an independent judiciary, and they need to have discretion and flexibility to consider the particular circumstances of a case, and there can be unintended consequences if they don't have that discretion. If that policy outcome were to be pursued, is there a better way of doing it than just removing the word only? So there's been a number of submissions with respect to how you would provide the relevant discretion in that clause. Does removing the word only get you there, or do you need to include a catch-all that includes any other relevant considerations the court considers fit? Or one of our other submitters, Mr. Justin McDonnell, who's a senior litigation practitioner with Kingwood Mallisons, referred to, I think his phrase was, the court should at least consider the following, which opens up discretion. Is removing the word only the way to achieve the outcome of providing that discretion, or does there need to be something particular inserted to the section? And maybe you can take that on notice.
I can respond quickly to that. We were seeking to be constructive in terms of the minimalist change required.
Yeah.
It would be desirable for abundance of caution to include a catch-all phrase that says such other factors as the court considers appropriate in the circumstances of the case.
Yeah.
The alternative of doing it, saying should consider at least the following, that I think concept is already captured by the words if you take away the word only. But I think the catch-all phrase you're referring to would be a very sensible addition with respect to avoid any misinterpretation, and that would be an area, for example, where you would limit, by doing so, you would remove possibly one area of satellite litigation, which is whether or not the court is constrained to this list. So it's a simple amendment, but I think technically with the removal of the word only, it does imply the court can take into account other factors, but it must take into account these factors.
Yeah.
But it would be better for abundant caution to have the extra words.
Okay, all right, I appreciate that. And Ms. Emmerich, have you had an opportunity to have a look at the submission from the National Farmers Federation?
I had a quick glance at it this morning. I can't say I've mastered every page, but I had a quick run through. If there's a question there, I can certainly do my best to address it.
Yeah, and look, I think I'd be interested in your views as a long-standing participant at senior levels in the profession. And the National Farmers Federation has given a view that this committee needs to consider not just the issue of percentage of proceeds, but if we are to consider the interests of class action members, we also need to consider how litigation is actually conducted. And that includes some of the proposed reforms they put forward were having mandated conciliation and mediation conferences at certain stages during proceedings, to restrict the number of strikeout applications in terms of pleadings, to provide a bit more reasonableness around the number of representatives at directions hearings and other hearings in order to try and mitigate costs. And the theme was along the lines that if you've got a class action of members, in many cases vulnerable Australians, who are bringing an action against a large defendant, might be government, it might be corporate, might be something else, then one of the issues for the plaintiffs is the litigation could be conducted in such a way as to prolong it, to defeat the aspiration of the class members. And the witness from the Mr. Rogers from the National Farmers Federation gave quite pointed testimony about how that contributed to the trauma suffered by some of the class action members who'd suffered great loss and were finding that an action was just continuing. To what extent do you believe, as a senior member of the profession, that there is room to provide for reform in terms of how class action litigation is conducted, in terms of the procedural mechanisms to ensure that actions can be completed as quickly and efficiently as possible for the benefit of all concerned? And I suspect you've discussed this issue over however long you've been a member of the profession. It's certainly been an eternal issue from my perspective.
Sure, and perhaps a couple of disclosures here. I have actually acted for the National Farmers Federation, but I think it might be 10, 15 years ago since I've last done that. And I have been for the entire 30 years of my sort of class action work a defendant lawyer. So I've got the submission in front of me right now. In terms of the things that you've referred to, mediations and strikeout speed limited and number of people in court and things of that nature. I think this is all really focused around the idea that defendants run these cases to generate the maximum amount of disruption and tactics to sort of bring on more applications to cause cost and try and somehow outspend the plaintiff. I think with respect to those who wrote that submission, I think that's an oversimplification, and I think it's also flawed in my experience. And for these reasons, at the highest level, and it's been this way for some time now, but you could look at, I refer you to Section 37M of the Federal Court Act, and it provides a binding obligation on parties in their court, which extends to the solicitors under 37N to give effect to the overarching purpose. That is, that they must give effect to running the case, resolving disputes according to law, but as quickly, inexpensively and as efficiently as possible. And that obligation sits on the lawyers as well. There's a power to regulate under the inherent jurisdiction. There are other regulations under state legal profession, national legal profession arrangements, which can also be employed if people are involved in engaging in conduct in breach of those obligations. I think what happens in these cases is that the stakes are often extraordinarily high. The sums in are very significant. The the impact on business and reputation, again, very significant. And as such, and they're very complex because of the number of parties involved and often the subject matter. And I'm afraid that for a large part of the period over a number of decades, there just has been uncertainty around a range of substantive and procedural laws, and it's just part of the normal process that some of those things get tested. But my bottom line point is that these cases are extremely complex. They are the largest and most difficult cases going through the courts, and I'm afraid with that comes a degree of expense. So it may well feel to others on the plaintiff's side that that there is just a lot of expense, and it must be because the defendant lawyers are engaging in shifty tactics. My experience is that the defendant lawyers, if they bring applications, are doing so because there are points to be tested, and defendants are entitled to have those points tested. If they overstep the line, then they are in breach of professional obligations, in breach of court rules and legislation, and there should be sanctions. And the courts have, in fact, engaged in that form of policing of the profession when there has occasionally been excesses. But that is a slightly different perspective to the one that I think is being advocated there. That said, I've been involved in court committees for a number of decades, and these are the issues that we wrestle over. Are there more efficient ways in which to try and conduct litigation? Mediations have proven to be very effective. Most class actions settle through a mediation at some stage. The timing of the mediation is critical. You can spend a lot of money on mediations, and so if you get it at the wrong time, it can be very inefficient. But mediations can be ordered by the court, they can be agreed to by the parties. So mediations provide a vehicle. Whether they're mandated at particular points in time, I don't really see a case for that for class actions. I think the court has a discretion, and it's a situation where the discretion is best exercised in the context of the case. Limiting strikeouts, look, you get some very badly pleaded cases. I've seen cases where the claim has had to be repleaded 5 or 6 times, and that is if the application to have the part of the claim or the claim struck out was without merit, then the court wouldn't have made those orders. And the purpose of the order is to help refine the pleading so that the issues between the party are as well articulated as possible to assist the court and to narrow the dispute between the parties. And in my experience, that's what the repleading often does. It does bring a discipline to the case, but I don't condone or see that there is a practice of bringing strikeouts just to generate extra cost. It's done, in my experience, for the meritorious purpose of trying to understand the case being pleaded. There are a range of other things you've described, and the paper goes through, and they're all points that have been considered by groups over the years on how to improve litigation. I don't think they sit in this bill. I think they're always worthy of reflection, and it's a constructive discussion to have. But from what I was seeing from the ones I read this morning, I think all of them, limiting costs that can be claimed by respondents to subpoenas. I mean, a subpoena goes to a third party; it doesn't go to the respondent, and it's the third party who's affected by the cost of having to produce documents. To limit the cost that third party can recover when it's been put to the burden of producing documents on a subpoena seems very unfair on the third party. Outlines of evidence, I'm just going through what I have in front of me here. With respect, that is definitely, look, it's worth raising, but it's a point we debate all the time in the context of trying to think about more efficient litigation. At the moment, the process has fallen towards affidavits. 1, because there's sworn evidence, and 2, because that means you don't need to call people in chief. The affidavit serves with an outline of evidence. The witness needs to go into the box, be taken through the evidence, and that's a more inefficient and time costing process, and the costs are horrendous enough without adding that to the mix. But again, I know the idea is well intended. What people are struggling for is more efficiency. Limiting the representation in courts is something I've spoken on publicly about. It's difficult. The parties need to be conscious of bringing to court only the right number of lawyers. Having excess lawyers there does not seem to me to be at all desirable, and one understands the reason why that might be raised. But again, I've seen courts regulate that by indicating controls around that. But at the end of the day, there is a reliance on lawyers and those legal representatives to make sure that they are running the case consistent with the overarching purpose.
So
but again, I was just going to say.
No, that's been very useful, Mr. Emmerich. And just in conclusion on this point, in terms of what is the right vehicle to consider these sorts of procedural issues, what's the right process? Where should these sorts of procedural issues be considered? The arguments for and against ventilated, and what's the role of the legislature in that, if any, or is it matter really for the relevant justices and the practice and rules committees? What's your view in terms of that?
In summary, my view is the latter. As a long-standing member of the profession, one thing I'm really proud of is the active way in which I see the federal and state courts trying to wrestle with this on a regular basis. And there are some differences in emphasis and views among the various jurisdictions and solutions to how it's wrestled with. But I can assure you that the courts and the profession engage on a regular basis, solicitors, barristers, court staff, talking about these matters. There are forums, there are liaison groups. For example, there is a federal court class action liaison group. There are state court class action liaison groups involving the judges and the profession, and these are the sorts of things that we wrestle with, and practice notes get adjusted, and it's a constant discussion. So my suggestion would be that these are probably matters best left for those sorts of fora with the judges and the participants who are dealing with this on a regular basis, because they're living and breathing the problems. Not necessarily a matter that requires at this stage, I would say, legislative intervention beside the framework that you've currently got. But just to give you some further example there, for example, the relevant courts, the key courts, Federal, New South Wales, Victoria, all have a class action practice note, which goes into great detail about process and procedure, including on the settlement of cases, for example, and articulates considerations to be taken into account and procedural matters. And in my experience, the courts are very clear in their articulation about the overarching purpose being taken very seriously at every step of the case by the profession, and they watch it with vigilance. So I hope that assists.
Okay, thank you. No, it does, Mr. Emmerich. Senator O'Neill.
Chair, before you move on, could I ask a clarifying question with regard to that particular matter that you were raising there? Because I think the National Farmers Federation had advanced 6 amendments, and when I asked them if they could support the bill, they indicated in their opening statements that the impact of the bill would be less access to justice for mums and dads who are wronged. Is it fair to characterise the amendments that they've put forward as not having any impact on access to justice, but rather discursive points about system response that could perhaps best be led by the Attorney General in conversation with the profession, rather than attempting to shoehorn structural change into a particular bill?
Well, look, I anticipate from the way I read my quick review of their submission was that they were proposing these as ideas for consideration by somebody to try and give effect to. But I would prefer to read them as constructive suggestions as to ideas that might be considered to help reduce the cost of litigation to all concerned and the burden on the system. But having said that, as I say, almost all of the ideas that they have raised, I can say I've sat on committees that have reflected on perhaps not the security for costs of the sliding scale. Look, pretty much everything here I've heard many times over the years put forward in the debate and merits debated and so on. So I would rather. Perhaps I have a slightly optimistic view about the world. I tend to approach these things on the basis that the legislators are struggling with the legislation, trying to work out what's the best way forward, trying to get guidance from those who work in the area, who have interest in the area, and we bring it all together and hopefully we get the right solution. We may not agree with everything that's said by other participants, but I mean, in this case, I would assume the Farmers Federation is putting these things forward as constructive ideas, and I think they should be received on that basis. But that said, I think the better forum for these ideas, these are really practice and procedure, is probably poor practice and procedure committees and the Australian Judicial College and bodies like that. There's a number of other outlets, I guess, which might be closer to the action, so to speak, that will understand the practical implications.
So to be clear, the recommendations from the National Farmers Federation, as well intentioned as they are and as relevant as they are, do not fix the Law Council's well articulated concerns with this bill.
No, they don't. They don't. To the extent they are put forward as ideas to try and reduce cost, we always support discussion on ideas to try and reduce cost. We don't. So we appreciate that sort of dialogue, so to speak. But the concerns here are sourced in other areas and more fundamental in nature. There's a little bit of overlap in some of the ideas raised here, but the common theme is cost is enhanced and returns are diminished by the legislation. There's a common theme there. But some of the solutions proposed here will not address the concerns that we have raised. That if that assists you to answer the question.
Mr. Emery, yeah. Senator Scott, do I have the call? Because that was only a clarifying one from me.
No, you do, Senator O'Neill, but I note that we're 20 minutes overdue for Treasury and the Attorney General's Department. I want to make sure we've got plenty of time with them. So you do have the call, but if you could just be mindful of that, please.
Thank you.
I have a couple of questions, Chair.
Okay.
To you, Senator Patrick.
Thank you.
So two very quick questions. One is that this term contradictor, I'm sure it'll be much vaunted by the government if they do decide to bring this terrible piece of legislation forward. But contradictor is a term, and practically contradictors have been appointed by judges in many of these cases already. This is not a new concept. It's just sort of labelling it and putting it in there, but it's already happening in practice. Is that correct?
That's correct, yes.
Thank you.
Yeah.
The other issue I think that's really significant is the government's proposing a very significant structural change by shifting opt-out to opt-in. In terms of socioeconomic status, legal literacy, perhaps being subject to trauma or grief and loss, how does an opt-in model as proposed by this legislation add another layer of restriction of access to justice to Australians? Why should it remain opt-out and not what the government's proposing in this legislation?
Well, there certainly are a number of reasons, and I'll refer you to our earlier submission, but just to perhaps address a couple of points. So, I think people who are likely to be most affected by opt-out, they will be, well, if we have an opt-in scheme, I'll give you the sort of legal analysis quickly. We have an opt-in scheme rather than an opt-out scheme. We're going to get multiplicity of class actions. That's going to increase the costs for everybody and make it more difficult to resolve cases. If you have an opt-in class action only, then there is still a group of people who have the same claim, but they are not part of this class action because they didn't opt in. They're still out there in the ether. If you settle this class action, then you're potentially exposing yourself to a second or a third or following class actions. And the idea that's been around for centuries is that litigation, the benefits to the public are in resolving litigation once and for all. So you've got more prospect of resolving an opt-out class action, which will give you an umbrella coverage as a defendant, and gives final resolution for all concerned. That's the sort of, and we discussed those legal analysis points in some detail. But beyond that, there are some other practical implications as well, particularly for Aboriginal and Torres Strait Islanders, people in rural areas, regional areas, people of low educational background, people who might be injured or have socially challenged in some way. They're often the people who have the most difficulty in being communicated with or getting access to information, not through any fault of their own. So there's a consideration there. So you've actually got a spectrum of considerations from some very pure legal issues through to some commercial realities, through to some social impact issues if you support this idea of a move towards the opt-in scheme. Remember that the legislation was introduced in 1992. I'm just making sure I get my years right. 1992. So we're coming up. This is our 30th year this year of the legislation, March 1992, at federal level, then state level, and it was following a report by the Law Reform Commission, an extensive study, and it looked at the choice between opt-in and opt-out, and it elected an opt-out model. That is, you had to select opt-out of the class action. And that's really been the whole fundamental theme behind class action law and procedure to this point. There are some complexities in that story, but it's a very, very fundamental shift to move towards a model that encourages only opt-in class actions. That's a significant and fundamental shift, and it's not a good one in our view for the reasons we've said in our submission, supplemented by what I've just said.
So less access to justice.
Less access to justice.
For people who have no experience with the law, and further uncertainty for actual respondents to claims, because they never know what might be coming around the corner because things won't get settled.
Well, yeah. So
bad for everybody.
Yes, bad for everybody. Yeah.
Thank you very much. Appreciate that, Mr. Emery. Thank you. Thank you, Chair.
Senator Patrick.
Thank you, Chair. Just operating the buttons. I'll just be relatively quick. When in your opening statement, and I might first apologise for interrupting you before, but I just wanted to try and get my head around
please.
What section of the Act you were talking about, so I could go to it while you were talking about it. But in your opening statement, you talked about constitutional issues, and you talked about head of power issues, and I'm just making sure that I understand that they in fact are the same, one and the same when you refer to those.
Yes, that's right.
Okay, and in doing so, you're relying on the submission that was made to the Joint Committee on by the International Litigation Funders, the advice that they received from Mr. Justice Gleeson SC and others. Or have you formed your own independent view of that?
No, it's a combination. We've formed our own independent view. We haven't relied on the litigation funders. I have had a conversation with Justin Gleeson about the matter, but the Law Council, the Class Actions Committee comprises QCs, senior partners from major law firms, and retired judges, and some academics and we formed our own view that there were significant constitutional law issues. But I certainly benefited very much from reading the opinion of Justin Gleeson, and that was attached to the submission of the litigation funding organisation.
Okay, so because in your submission you said the Law Council had not had the opportunity to consider these issues in depth because you'd referred to the corporation's power issue,
That's right.
Intergovernmental issue, and indeed they also raised the issue of Section 3 and
Chapter 3, yeah.
Sorry, Chapter 3. Being the in some sense the judiciary acting in its independently of the Parliament. So just to be clear, because you sort of put a caveat on it saying you hadn't really considered in detail, has that situation changed since you made your submissions?
Yeah, so the context was I think we'd had about 5 days to consider the draft legislation, and that included a weekend period. We held a number of committee meetings to discuss the legislation, and we're debating its impact and its terms and what we might say to help assist the Parliament. In the course of that, I raised personally a number of points of constitutional concern. Others shared that view, but we didn't have time in that short period to fully iron out all the nuances. I've had a bit more of a look at it since that point in time, but frankly, in light of the considered opinion of Mr. Gleeson, I've deferred to Mr. Gleeson on constitutional issues, and I think that's probably the most beneficial source. It certainly covers all of the points that had occurred to me, and some additional points.
And just my final question, Chair. So just to be sure in my mind, if the Parliament were to proceed with this legislation in its current form with these constitutional questions hanging in the air, I presume it might come to a point where some litigation commences, and the restraints or the regulations under within this bill get confronted in some way. We might end up with someone either proceeding without regard to the legislation, or indeed somehow challenging the legislation. That's generally what happens in these instances.
Yes, I'd say that's inevitable. I'd be very surprised if there is not a constitutional challenge to the legislation.
Because the very people who are interested in this do litigation all the time. So
I would say because these cases are very expensive to run, and I think the investments that would be made by or considered being made by some interests, they would want as much certainty about the rules of the game. And if they're constitutionally questionable, I would anticipate that they would seek to challenge and have it dealt with that way. That would be a rational commercial approach.
And the response from the government may be to this committee, don't worry, we've got this sorted out. What do you say to that?
Well, look, there seemed to be, the question they were being asked was, please advise the head or heads of power that the government relies on, and that means heads of constitutional power. And as I understand the answer, they said they took legal advice and therefore I'm in a position to disclose the heads of power. I think there are two mixed concepts there. One is taking legal advice. They're entitled to take legal advice and they're entitled to hold their legal advice. But they should be able to answer for legislators the question of what heads of power are being relied on by the government. That doesn't require revealing the legal advice. It's just requiring saying these are the heads of power. Now, the legal advice may no doubt consider the merits of those heads and the strength of their availability to support all or part of the legislation. But the simple question of what heads of power are you relying on, it seems appropriate to the Law Council that legislators should be informed of that. We're not saying anything about legal privilege, but even in the event that
they thought that it might involve disclosing advice. The waiving of privilege is a part of the doctrine of legal professional privilege. It doesn't undermine it, does it?
Well, I probably hold. Look, people are entitled to take advice, and they're entitled not to waive privilege, and that extends to corporations and it can extend to governments. But I think the question is, it's not necessarily a matter of privilege to say we are relying on Section 51. 20
I
or
guess
5139.
my point was, and this is because I'm going to have this discussion with the Attorney General's Department, is often they say it's legal advice, therefore if we disclose it, we cause harm just because we undermine the doctrine. And that's not actually the case. The doctrine itself of legal professional privilege, my understanding is, permits a client to disclose advice. And that doesn't mean the next time around they don't that they're obliged to. The doctrine still exists, and it still protects them for things that are not disclosed.
A waiver in a specific case does not necessarily produce a waiver in other cases, but
the doctrine supports it, doesn't it?
But beyond the doctrine supports a right to waive privilege and a right to maintain privilege. But they are elections for those who hold the privilege.
Senator Patrick, could I just ask one quick question on this point of Mr. Emerick before?
You're the chair. You can do whatever you like, Chair.
He's going to write a great report, Senator Patrick, and recommend that we dismiss this bill because it's so badly written.
Senator O'Neill, I'm keeping my counsel.
If I just make one comment and then I can finish and then you can come back to them. I just would make the point that under the Hawke government, the Cabinet made a decision under the Secretary of the Attorney General's Department, Mr. Brazil, that legal advice is actually funded by the taxpayer and they're entitled to see it, except in circumstances where revealing it would cause harm. And I think that's a doctrine that should always be adopted by governments, recognising who pays the bills. Anyway, the real client is in fact the public.
Okay, all right. Well, thank you. Thanks for that, Senator Patrick. And Mr. Emerick, I do suggest that if the Law Council does have an FOI practice committee, that they invite Senator Patrick to attend one of your meetings to give his personal experience and reflections on that matter. I just want to ask one particular question before we move on to the next witness, and it's in relation to this waiver issue. From your perspective, in a situation where legal advice is obtained and the person who's in receipt of that legal advice then provides a view, which is dealt with in the legal advice, but they're providing a view. And the legal advice might say, well, we think this is the better view, or we think there are these problems with the view, or whatever, but they're providing, the person who received the advice is providing a view to a committee such as this, such as the head of power under which this legislation falls is head of power X. Does that in itself constitute a waiver of the underlying does that constitute a waiver of legal professional privilege in the advice that was obtained? From your perspective, is there any risk of that, or is there a risk of that?
I'll give you a sort of layered answer. The specific detail will be relevant to the answer, but you could, for example, indicate that I hold a particular view on a matter, provided you don't say based on legal advice or based on the advice of, in this case, might be the Solicitor General, or cite the source or reference to legal advice, then the mere articulation of a view doesn't of itself waive any privilege in a legal advice that you may just happen to hold. So if that would be I think a traditional analysis. And for the same reason, if you were to say, if a question were asked on what powers is the Commonwealth relying for this legislation, and the answer were to be given, it's Section 20, it's 5139, 5137, If there were no reference to the legal advice, that would not waive the legal advice, in my opinion. But I'm speaking in fairly generalised terms, if that assists you.
So is it fair enough, again, just in general terms, but before we go, as we lead into the next witnesses, if there has been reference to legal advice as obtained, and there references to dates of legal advice, then is it fair to say that the issue becomes more complicated when the view is given on the basis that legal advices have been obtained and are known to have been obtained?
The whole area of privilege is very much one that turns on the specific words and combination of words and the combination of communications. So I wouldn't offer an answer to that question because it could be misleading.
No, that's fine, Mr. Emery. Can I thank you for appearing today? Can I also extend this committee's thanks to the Law Council of Australia Committee, Class Action Committee, who have obviously done a lot of work in relation to this, in some cases in response to very tight timetables. So thank you very much. It's been very useful. And,
a pleasure. Thank you.
Okay. So you can certainly, if you could disconnect, but certainly feel free to follow proceedings through PAL View if you would like.
Thank you.
I now welcome representatives from Treasury and the Attorney General's Department. Thank you for appearing before the committee today. So I see Mr. Dixon again, wearing many hats. If I could maybe, I'll read my blurb first. I remind officials that the Senate has resolved that an officer of a department of the Commonwealth or a state or territory shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked to the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I'd also like to advise witnesses that answers to any questions or notice should be sent to the Secretariat by 24 January 2022. And I invite the representatives, if you have an opening statement, and I understand the AGD has an opening statement, but I might just ask Treasury first. Does Treasury have an opening statement?
It's Tom Dixon here. No, we don't.
Okay. And then I'll pass on to the Attorney General's Department and ask whether or not you have an opening statement. Sorry, I think you're on mute. You just.
Can you hear me now?
Yes, I can.
Thank you. So, technical help there to assist.
No.
Alban Snowdell, Assistant Secretary, Legal System Branch, Attorney General's Department. Thank you, Chair. Yes, I do have an opening statement in response to the request from the committee to provide a chronology in relation to the history, I guess, of the Parliamentary Joint Committee's consideration of the constitutionality of the bill as well. So I'll commence to read that opening statement if that's fine.
Thank you, Dr. Smerdell.
The committee has requested that the Attorney General's Department provide a full chronology and background to the Attorney General's claim for public interest immunity over legal advices in relation to the Corporations Amendment Improving Outcomes for Litigation Funding Participants Bill 2021. On 12th of November 2021, in a public hearing of the Parliamentary Joint Committee on Corporations and Financial Services, the Department was asked questions by committee members relating to the constitutionality of the Corporations Amendment Improving Outcomes for Litigation Funding Participants Bill 2021 and the source of the Commonwealth's legislative power to sustain the bill. The Department stated the government had received a number of legal advices relating to the constitutionality of the bill, including from the Solicitor General. The Department assured the committee that, on this basis, the government was confident that the bill is constitutional. In accordance with government guidelines for official witnesses before committees, the Department took 4 questions on notice relating to the content of legal advices sought on the constitutionality of the bill. indicating also that the Attorney-General, Senator Dion Macalia-Cash, may wish to make a claim of public interest immunity over the content of legal advices provided to the Department. On the 16th of November 2021, in response to questions taken on notice, the Department provided the relevant dates of legal advices received on the constitutionality of the bill. Responses noted that, in accordance with long-standing practice of successive Australian governments, it is against the public interest to disclose the contents of confidential legal advice. The Department's responses noted that it is important that the government can engage with legal advisors fully, frankly, and with confidentiality. A copy of the responses can be found on the committee's website. On the 19th of November 2021, the Parliamentary Joint Committee made an order to the Department to produce, on a confidential basis, all legal advices relating to the constitutionality of the Corporations Amendment approving outcomes for litigation funding participants Bill 2021. On the 24th of November 2021, the Department notified the Parliamentary Joint Committee that the Attorney General intended to make a claim of public interest immunity on the legal advices received by the Department. The Attorney General wrote to the Parliamentary Joint Committee on the 24th of November 2021, making a claim of public interest immunity over these legal advices. In her letter to the committee, the Attorney General stated that it has been the long-standing practice of successive Australian governments to not disclose privileged legal advice, and that it is not in the public interest to depart from this established position. The Attorney General noted that it is integral to the development of sound Commonwealth policy and robust lawmaking that privileged legal advice provided to the Commonwealth remains confidential. The Attorney General noted the specific harm that would result from the disclosure of confidential interactions between lawyer and client would be to the administration of justice by discouraging full and frank disclosure between clients and their legal advisors. On the 25th of November 2021, the Parliamentary Joint Committee requested that the Department appear at an in-camera hearing on the 26th of November 2021 to further discuss the constitutionality of the bill. The Department appeared at that hearing, but was unable to assist the committee's inquiries given the Attorney General's claim of public interest immunity. On the 2nd of December 2021, the Department corrected a response to a question on notice sent to the committee advising of 2 additional legal advices that had been received prior to the public hearing missed in the original response due to oversight. A copy of this letter can be found on the committee's website. On the 29th of November 2021, the Parliamentary Joint Committee, Corporations and Financial Services Committee Chair, the Honourable Tony Smith MP, wrote to the Attorney General advising the committee did not accept the Attorney General's claim of public interest immunity on advice from the Clerk of the Senate, stating the claim did not meet the requirements of the Senate. However, the committee noted it did not intend to press the claim, noting the head of power and constitutional validity of the bill may be clarified when the bill is debated in the Senate. Thank you, Chair.
Thank you, Dr. Smerdel, and I guess here we are in a Senate committee considering the issue as part of the next process. Can I just ask you an opening question, and then I'll pass on to Senator O'Neill and then to Senator Patrick. But just on this issue in particular, why is it that the Attorney General's Department can't provide a stated view with respect to the head of power, which grounds the legislation which we're currently considering, provided that that does not constitute a waiver of legal professional privilege itself? Is the concern that the simple positing of a view with respect to the constitutional ground would constitute a waiver of legal professional privilege? Is that the concern as to why the Attorney General's Department feels it is unable, given the public interest immunity claim, to provide the heads of power?
Thank you, Chair. I think that's basically the proposition, that our concern is that given the raft of legal advices that we have received on this particular bill, it's very difficult to disentangle anything from just commentary to something that we're drawing from our legal advice. And so I think out of the 11 legal advices that the Department has and the Treasury have received in relation to the bill, 7 of which are constitutional legal advices, there's a lot of detail in there that we're concerned, and basically we will take the view that the attorney's legal public interest immunity claim, which is that it will be inappropriate for the contents of such advice to be disclosed to the committee, also covers the heads of power.
Okay, so if we accept that proposition, and I'm just putting to one side the argument about the public interest immunity claim, I'm at the outset, I'm concerned about the practical consequences of this, because there will be cases where the Commonwealth Government obviously needs to get constitutional legal advice with respect to complicated matters. And it seems to me somewhat concerning if every time the federal government gets constitutional legal advice in relation to a particular matter, and I appreciate how complex and difficult this could be, that is going to prevent the Commonwealth or the Attorney General's Department from positing a view with respect to the head of power that applies, because the Attorney General's Department is going to be concerned that by positing that view, that act in itself is going to lead to a waiver of legal professional privilege, and they're going to have to give the legal advice. So, for example, in the situation this committee faces at the moment, we've been given constitutional legal advice being provided to us. I guess that's an example of a waiver of legal professional privilege, or the advice was prepared for that purpose by a party that previously submitted to Parliament in relation to this matter. And that advice is before the committee. And then when the Attorney General's Department appears, because of your concern, the department's concern about legal professional privilege, you're prevented from positing a view with respect to the particular head of power that the legislation is being made under. It's a problematic situation, isn't it? Is there a pathway through this? Because it just seems to me a real practical issue that the Senate is going to need to consider this legislation in circumstances where, in order to protect legal professional privilege under the public interest immunity claim, the Attorney General's Department considers it can't posit a view with respect to the head of power, when certainly other parties, left, right and centre, are positing their view.
Thanks, Chair. I certainly appreciate the concern, and to a certain extent our hands are tied because the attorney has already made the public interest immunity claim, and I'm assuming that's recognised by this committee. But if
Chair, can I interrupt there, because I think it's very important, even though I don't have the document in front of me that Mr. Smerdle was just reading from, that he did put on the record that the letter was sent to the Attorney General by Mr. Tony Smith as the chair, the recently appointed chair of the PJC. And he stated accurately, Mr. Smerdle stated accurately, that the committee did not accept the PII claim of the Attorney General. So it's very, very important to be clear that claim, although made, has not been accepted. No, so any impression to create for the committee or for the record that the claim by the Attorney General has been made and accepted is to absolutely misrepresent the reality.
Well, Senator O'Neill, it's a very good point you make, but Dr. Smerdle's opening statement made it quite clear, as you said, and I appreciate you might not have it in front of you, but it did make it quite clear that the public interest immunity claim was not accepted by the Parliamentary Joint Committee on Corporations and Financial Services Committee, on which both you and I sit. And one of the reasons I asked the Attorney General's Department to provide a detailed opening statement with a chronology was to make sure that's clearly on the public record. So
thank you. I agree with you, Senator Scarron. I thank you for the line of question because it's fundamental to what we're considering. But I was concerned that Mr. Smerdle was creating the impression that might. Well,
I'll give you an opportunity to respond to that, Dr. Smerdle. But my understanding of what you were saying was you weren't aware of what this committee's position was with respect to the claim of public interest immunity. You weren't talking about the previous committee, which you discussed their position in your opening statement. Is that correct?
Thank you, Chair. That's correct. I'm not an expert on Senate practice, so I guess I'm a little unclear myself as to what's the status of the Attorney General's claim public interest immunity.
Well, no claim
Hold
has been
another
made
one
to this
needs to be
committee.
made, or what the position is.
No order has been made by this committee, and no claim has been made in response to an order. So that may come, but I don't think it's fair to say it anyway that the committee would accept that position. Hasn't been asked to do so.
Okay, thank you, Dr. Smerdel. So from my perspective, I understand the issue, but you also seem to appreciate the position this puts the Senate in, where you have a situation where stakeholders are positing their view with respect to the constitutionality of the bill that has to be considered by the Senate, and the Attorney General's Department is now in a position where, whilst it can provide its general view with respect to constitutionality, it feels that it simply can't go into the detail with respect to matters such as heads of power.
Can I just warn the official that it is my intention to move a second reading amendment that sends this bill back to this committee until it's satisfied as to the constitutional power. I've done that in the past where departments have refused to provide necessary information, and it just leaves the bill in a situation. You might think you can get the numbers to get the bill through, but the Senate has stood up in the past and just refused to deal with the bill until such time as these questions have been answered. And you might want to seek some urgent advice from the attorney as to whether or not she wants to have to deal with this. And you might also suggest that the concern comes from me, and it might affect the way in which I deal with her on other bills.
All right. Well, Senator Patrick, we'll take that as you've foreshadowed. Thank you. Your concern, and you made your position quite clear in that regard.
I will have some questions on it as well, but when my turn comes around.
All right. So I'll turn to Senator O'Neill. You have the call, and thank you for your indulgence to allow me to flesh out those opening.
Sorry, Chair. Can I just ask one question of the committee? Can I take it then that the attorney's previous claim for public interest immunity is no longer extant, and so if another claim needs to be made, rather than just assuming that one might still carry on?
Dr. Smerdel, I might need to take advice on that, but certainly, as Senator Patrick said, an order for production had not been given by this committee. There was a claim made by the Joint Standing Committee with respect to the matter. So it is a procedural question as to whether or not that claim is extant with respect to the operations of this committee. I'd probably need to take some advice on that and come back to you. But I suspect, if I can suggest to you that the expectation would be that given this is a committee of the Senate and the Parliamentary Joint Committee with respect to the Corporations Law and Financial Services obtained the advice from the Clerk of the Senate and put forward a very strong view, subject to discussions with members of this committee, I suspect you could reasonably anticipate what the view of this committee will be with respect to that claim.
Thank you, Chair.
Senator O'Neill.
Thanks very much, Chair. And of course, it seems to me entirely fundamental that we should never be legislating if there is any doubt that there is not a head of power under which we are seeking to legislate. That's absolute basics. So if I can go to the nature of the discussion about the constitutionality of the bill that's exercised us already, could I ask, since the Parliamentary Committee on Corporations and Financial Services has tabled its report, has the Treasury or the Attorney General Department sought further advice on the constitutionality of the bill in addition to what it was that you documented in your opening statement?
Perhaps since you mentioned the Treasury first, it's Tom Dixon here.
Thank you, Mr. Dixon.
So I'm not aware of us seeking additional advice, but I can take that on notice. But to my knowledge, we haven't sought additional advice.
You have not.
Well, to my knowledge, I haven't, but I'd prefer to take it on notice just to give you a absolute assurity that that's the case.
Thank you, Mr. Dixon. Mr. Smerdle.
Senator, I can advise that subsequent to our initial appearance before the Parliamentary Joint Committee, but prior to the tabling of the Parliamentary Joint Committee's report, the Attorney General's Department did seek some additional legal advice from the Australian Government Solicitor.
And on what date?
Date was the 16th of November, and we received that on the 23rd of November.
So is that documented in that timeline that you've provided?
That document is not in that timeline.
Is there anything else? Could you amend the timeline to indicate that evidence, please? And is there anything else that we should know about with regard to the constitutionality that has been undertaken that is not yet in the timeline that you've provided to us this afternoon?
We can do that, and no, there is nothing else to add.
To the best of your knowledge. So we're talking about an additional piece of advice sought by the government on the 16th of November, provided on the 23rd of November, as to the constitutionality of the bill. Is that correct?
Correct.
Thank you. Now, neither the bill nor the explanatory memorandum identify the source of the constitutional power for measures in this bill. We've referred in evidence this afternoon to the advice of former Solicitor General Justin Gleeson. I'll repeat just a brief section of his submission, which states that it is insufficient attention has been given to the source of the Commonwealth legislative power to sustain the bill. Could I ask, could the Attorney General's Department please tell this committee what is the source of the Commonwealth legislative power for the measures in the bill? What part or parts of the Constitution are you relying on? And I ask you to be comprehensive in your answer.
Senator, as explained to the Chair, we would still consider ourselves to be covered by the terms of the Attorney's Public Interest Immunity Claim. Now, I fully comprehend the discussion that has gone on beforehand and the committee's concerns with that, but I'm not in a position to provide an answer to that now at this hearing. I would need to take further advice in relation to the Public Interest Immunity Claim.
So to be clear, Mr. Smerdle, you're refusing to provide this committee with an answer to its question about the fundamental constitutionality of this bill, despite 11 advices, perhaps now 12 if we add in the evidence you've just given me, 7 of which were constitutional legal advices. Despite all of that, you still cannot point to a head of power. Are you making a public interest immunity claim?
Well, I can't make a public interest immunity claim, Senator. That's a matter for the Attorney General. As we've discussed previously, this department has interpreted the public interest immunity claim that the Attorney General had previously put in to cover not only the content of the legal advice, also covers the heads of power. So we haven't been able to provide that up till now, and I can't suddenly turn around and provide those heads of power. Now we would consider that still covered by the terms of the Attorney's
Well, whatever you might consider, Mr. Smerdle, the reality is, in your opening statement, you acknowledge that you understand that the committee that received that public interest immunity claim from Senator Cash as the Attorney General was rejected. That's a fact, right? So you can't rely on a claim that was rejected by another committee. And you may come here with writing directions from the Attorney General, but this is the Senate, the Economics Committee of the Senate, inquiring into access to justice through litigation funding, a very complex piece of legislation. You are representing the Attorney General, but you should be able to answer basic questions. Is this bill constitutional, and on what head of power are you relying?
Senator, in response to what the Parliamentary Joint Committee said, it also said it did not intend to press the claim. So that's why I've asked this committee as to what's the status of the Attorney's public interest immunity claim. But I'll need to take that on notice because our current position is that the Attorney General's public interest immunity claim still covers the heads of power. So if the Attorney General's current public interest immunity claim is no longer extant, then I'll need to take that on notice to see what the Attorney General's position is, because only Attorney General can make a public interest immunity claim.
I have to say I'm very, very concerned at this point of time that given the signal that was so clearly given to this, to the department and to the Attorney General by that committee, respectfully saying that the claim wasn't made out, that you have not come prepared to answer questions which I think were entirely foreseeable. Can I just point you, do you have a response to that assertion by me, Mr. Smerdel?
Sorry, which assertion?
That you have come unprepared to answer these questions about the constitutionality of the bill. Is that the case? You have come unprepared?
Well, I wouldn't characterise it unprepared. I'm just saying that the department still considers it that the Attorney General's public interest immunity claim still holds.
Well, we have already made it clear that that is not the case. So my question is, have you come unprepared? And you said, no, you're not unprepared. So you should then answer our question.
No, but I've also
what is
said
the constitutional
if
basis
the Attorney
on which
General's
this bill
previous
is
public
founded?
interest immunity claim no longer holds, then I'm taking it on notice to see if the Attorney General wishes to consider putting in a new public interest immunity claim.
So if I could just point out that Section 64 of the Religious Discrimination Bill, another bill that's under consideration at the moment, is entitled The Constitutional Basis of this Act. And that piece of legislation, as complex and contested as it is, sets out the constitutional basis of that bill in the bill itself. Okay, paragraph 561 of the explanatory memorandum for the Religious Discrimination Bill says explicitly that the external affairs power is the main constitutional basis for this bill. So, based on the logic of the Attorney General's department, the government has waived legal professional privilege over any legal advice it received about the external affairs power being an adequate constitutional basis of the Religious Discrimination Bill. And they have indicated what head of power that they seek to implement that piece of legislation under. So isn't it the case that the argument that you make about waiving legal, any privilege, professional privilege over legal advice cannot stand?
I understand where you're coming from, Senator, but I've also indicated that I need to take the question on notice to test what the Attorney General's view is in relation to proceeding with another public interest immunity claim.
I think that we need to let the record show here that as a member of this committee and having served on the joint committee that inquired into this matter, that this has been a profoundly rushed set of inquiries. It's a terrible piece of legislation that's been roundly condemned by people who would be plaintiffs, people who would be respondents, and as yet has no clear constitutional basis. Now, the truth is that if the government were confident about the constitutional basis of this bill, it would tell us what the constitutional basis is. It does that all the time in relation to lots of bills without reference to legal advice and without any risk of wavering privilege over advice. Isn't that the case, Mr. Smerdel?
Well, I can't comment on other bills, Senator.
But you do have some experience, given your seniority. When you're preparing a bill for the Attorney General, please tell me that you check to make sure it's constitutional before you advance it.
Well, I think in this case, the fact that the legislation has been subject to a number of legal advices, 7 of which related to constitutionality, that it demonstrates that the Commonwealth is taking the constitutionality of the provisions very, very seriously. And sorry, Senator Patrick's on mute.
He's probably expressing amazement.
I was just wondering whether or not there was some advice shopping going on, that that there were seven pieces of advice on the constitutionality of the bill.
So I'm not familiar with the term advice shopping, but there's...
So,
Perhaps another way of putting that, Senator Patrick, is to put the question as was advice obtained from more than one member of senior council?
So in terms
Can you
of
answer that question, Mr. Smerdle?
Can you be free to take that on notice?
In relation to the advices received in constitutionality, one of them was from the current Solicitor General, one of them was from Perry Hertzfeld, Senior Counsel, and the rest were from the Australian Government Solicitor, mainly from Leo Hardiman, who was the Deputy Chief General Counsel of the Australian Government Solicitor.
Okay, thank you, Dr. Smerdle. Back to you, Senator O'Neill.
Thank you. And can I just clarify that that's the 7 constitutional legal advices that you indicated on the timeline? What about the one received on the 16th of November or requested on the 16th of November, received on the 23rd of November? Was that included in your summary there, or is that an additional one?
That's correct. It's included in that summary.
Thank you very much. Now, given your responses to date, could you on notice please identify the constitutional head of power that supports each and every provision of the bill? So I literally want you to go through the bill and tell the committee, for example, section 601 LF is supported by the following heads of power, and list the heads or the head of power that you're relying on for that provision. And I request that you do that, and I hope I have the support of committee to do this for every section of the bill. So I am not asking you, to be clear, to disclose legal advice. You don't have to provide an argument, although if you are so inclined, I would be happy to receive it. You do not have to tell us why you're relying on a particular head of power to support that particular section. But I think we're absolutely entitled as senators called on to legislate to be confident that every section of the bill has a head of power on which it can rely.
Thank you, Senator. And yes, I'll take that on notice, but as discussed previously, it's also tied into the question of what the attorney will do in relation to a public interest immunity claim as well, but I'll certainly take that question on notice.
And I appreciate your reasonableness, and I'm sure that you are highly professional in the work that you do. But the point, Mr. Smerdle...
And I appreciate you making that point, Senator O'Neill.
Well,
it's
important.
It's well made.
Yes, thank you. Thank you, Chair. But the point is that the government tells committees and the Parliament the constitutional basis of legislation all the time. It's often set out directly in the bill. There is never a suggestion that doing that by actually being transparent about the head of power on which the legislation relies amounts to a waiver of legal professional privilege, because the government happens to receive legal advice on a constitutional basis. So I think that that argument is very flawed. It's certainly run its course, and it's time for the committee to be given what it needs. On notice, could I also ask the Attorney General's Department and the Treasury to provide a written submission to this committee which addresses the concerns about the bill raised in the 15 submissions received by this committee? We've had a truncated hearing this afternoon, although I do note with thanks that the Chair has adjusted the time to allow questions to be asked. And I'd like you to focus particularly on the concerns set out in submissions by the Law Council of Australia, who remain concerned about the constitutionality, in addition to other matters, and also the submission of Marland Law. And again, if I could ask you to provide a response to each of the considered recommendations suggested by the National Farmers Federation in its submission, and to inform that perhaps the view of the Law Council in the evidence that they just gave us might be important for you to have a look at as well. Now, I can say it's up to you how you craft your submission, but I really do insist that you provide responses to each of those submissions and that you engage in detail with the multitude of concerns that have been raised by these diverse submitters. And of course, I'll have a series of other questions I noticed. Chair, I've got a few more, if I may continue. Thank you. Going back to the report by the Parliamentary Joint Committee on Corporations and Financial Services, Has the Attorney General's Department and has Treasury reviewed that report, including the dissenting report by Labor members of that committee? Perhaps go to you, Mr. Dixon, first.
Yes, we have.
Thank you. And Mr. Smerdel?
Yes, we have too, Senator.
Okay. Do you have any commentary to make about that dissenting report?
No, Senator, I don't have any commentary in particular.
Mr. Smerdel?
No commentary either. Thanks, Senator.
Thank you. I don't know if you'd be able to help me out with this. Again, to both you, Mr. Dixon and Mr. Smerdel, why hasn't the government, do you have any insight into why the government has not provided a formal or in fact any response to the Parliamentary Joint Committee on Corporations and Financial Services report on this bill?
Sorry, Senator, could I just clarify? Are you asking why they haven't responded to the dissenting report?
Yes, are you aware? Well, they haven't responded to the committee report at all.
I understand what you're saying, Senator. I think the government's response has been through the actions that it's taken in order to progress the policy settings that it's looking to put in place.
So the response to the report was ignore it and bring the legislation into the House anyway. Is that what you're telling me?
No, not at all, Senator. In fact, the PJC report is actually referenced in many materials that go behind some of the policy settings that have been progressed. So, yeah, it's quite the opposite, Senator.
So,
sorry to interrupt, Senator O'Neill. I just want to get the evidence clear on this, Mr. Dixon. When you say the PJC report, you're not actually talking about the Joint Parliamentary Committee report on the actual bill. You're talking about the previous Joint Parliamentary Committee report in terms of class action litigation. Isn't that correct?
Yes, correct. Sorry, I apologise if I've got my wires crossed.
I think Senator O'Neill is talking about the report on the bill, on the draft bill that was made by the Parliamentary Joint Committee, Corporations, Law and Financial Services. Is that correct, Senator O'Neill?
I am indeed. Thank you for reading my mind. Thank you very much, Senator Scarr. So
I apologise. That was my fault. I got my wires crossed. So you're in terms.
Well, there have been a number of reports, but you know they're quite at odds with one another. So, Mr. Dixon.
So, in terms of then responses, I'm not aware of a government formal response to that particular report that you refer to.
Right, and do you have any idea why that is the case, or have you been asked to draft anything?
I would have to take that one on notice, Senator.
Thank you very much. Mr. Smerdel.
Senator, I don't think I've got anything to add to Mr. Dixon's reply other than to note that I think that report came out in the last sitting week of the last of the calendar year, and Parliament hasn't resumed yet for this year. So I'm sure there are efforts still in train, but I can't precisely comment on where that response is up to.
Right. So, to the best of your knowledge, there is no formal response under preparation. Is that correct?
To the best of my knowledge, I'd say that it's still, that's still a matter internal to government, but there is still time to, and it's not unusual for legislation committee reports to be responded to during the debate of a bill as well.
So the fact that it's already gone through the House is not an impediment to the government to actually respond to the concerns raised by the dissenting report by Labor senators and the single recommendation by government senators, or government members, sorry. That could yet be done, is what I'm asking you. Is that correct?
Sorry, I missed the last bit, Senator.
That report could yet be done and arrive into the Senate in the coming days.
What I'm not sure about is what form that will be, whether it's a separate government response or whether it's dealt with during the course of the debate on the bill.
So, to be clear, there's been no draft response to the report, the most recent report by the Parliamentary Joint Committee on Corporations and Financial Services.
So Senator, it's Tom Dixon here from the department. I think I can take that on notice because naturally there are developments that are possible, and it would be important for us to just make sure that we've understood the question, but also whether there's been any work undertaken that I might not be aware of.
Okay, and just for my clarity, the initial report that we first referred to, has that received a response from the government?
So yes, I believe so, Senator.
Okay, thank you. With regard to the most recent report, has the government accepted the recommendation by the government members of the Parliamentary Joint Committee on Corporations to delete the word only from section 601 LG, section 3 of the bill?
So I'm not aware of any government decision to do that, Senator.
Okay, Mr. Smerdel, has that been accepted?
Well, I'd concur with Mr. Dixon's advice.
Sorry, which is what?
Well, he said he wasn't aware of any such amendment or such agreement to that recommendation.
Okay, have you prepared any amendments that would indicate that there's been an acceptance of that recommendation by the government members of the Parliamentary Joint Committee on Corporations and Financial Services?
Senator, I can take that on notice when we have various areas in the department that deal with law reform matters, and so I can investigate that for you.
Could I get clarity? Would it be Mr. Smerdel or Mr. Dixon who'd be responsible for preparing amendments for the Attorney General to consider? Or would you advance them jointly?
It's for the Treasurer and the Attorney General. So I think in relation to details of the scheme, Treasury would be the lead on that.
Okay, so the government has not necessarily rejected, or have they rejected the recommendations by the government members of that report?
Senator, I think I can clarify that I'm not aware of a decision being made one way or the other.
Okay. Are you aware of amendments being prepared to the bill since it's passed the House?
So just going back to my earlier question, I take that on notice to find out from other areas in the department whether there's been any instructions given around amendments to the bill.
But you're not aware?
I'm not aware.
Thank you.
And Mr. Smerdel, are you aware, how closely involved with this bill are you?
Is that a question to me or to Mr.
Yes, Mr. Smerdel.
How closely involved am I? I'm not the action officer on the bill, so the action officers might be aware of things that I'm not aware of, but there is certainly, I'm aware that consideration is being given to the bill, but that's still a matter for government. There's a difference between a consideration and between decisions that have been made.
Yes.
The PJC put up a particular recommendation which is certainly being given active consideration.
Yes, and the dissenting report put up a number of other recommendations. Is that being given consideration?
All recommendations being made by committees are given consideration, Senator.
Some more than others. Could I ask you, with regard to this particular process that we find ourselves in right now in the middle of January, which is sort of an extraordinary period of time to be doing this, and gives me the sense of the rush to try and push this legislation through. Is that the reason, or is there some other reason why the Treasury and the Attorney General's Department didn't bother to provide this committee with a written response, a written submission?
Yes, Senator, I think in terms of the characterisation, as my colleague pointed out, I think some of this material and viewpoint was developed by the committee prior to Christmas, quite late in the calendar year, and the point in time that we're in now, it's not it's not an enormous amount of time taking into account the other developments, leave and other things in the period. So I would say that I wouldn't characterise it necessarily as a failure to provide a response at this stage. And as my colleague pointed out, there are a number of avenues if the government did want to respond to it, including during the debate.
Look, I take your point about the extraordinary nature of having this inquiry at this point of time. But Mr. Dixon, how many people are there in Treasury?
How many people in Treasury in total? Well, I could give you a rough idea of somewhere between around 1,000 people probably.
And how many people working on this bill, Mr. Dixon?
So in Treasury, in my team, I have a small team that of around maybe 4 or 5 people that look specifically from the point of view of Treasury's boundaries on this. And then
Could I ask Mr. Smerdle the same question? How many people in the Attorney General's Department? Sorry, go on, Mr. Dixon. Yep.
Yeah, there's a bit more. So we also have an area of our department which is called the Law Division, and we have people that work in the Law Division. I'm not quite certain as to how many people in the Law Division contribute to that, but that's where a lot of the actual nuts and bolts of legal preparation takes place. In addition to then, my colleagues over at AGD.
So there's quite a few people allocated to this task within the Treasury. Roughly 10, perhaps.
So that would be inclusive of their other responsibilities. So
Okay.
they wouldn't solely work on just this matter.
Thank you. And Mr. Smerdle, how many are in Attorney General's Department and how many working on this particular matter?
That's a good question, Rise Family, in the Attorney General's Department, because it also contains the Australian Government Solicitor, who are lawyers to government. There's certainly north of 1,000 in relation to how many people are working on this bill. I would say similar to Mr. Dixon, about 4, 5 people, but similarly to Treasury, that they also are responsible for progressing other areas of work as well. So no one will be solely dedicated to working on this bill.
Now, given the resources of the federal government, the considerable number of people that you've spoken about who are in the department and the allocation of the number of staff to this, it really beggars belief that 15 individuals and organisations, all who I would generally say have far fewer resources at their disposal than either the Attorney General's Department or Treasury, went to a great deal of effort in the same time frame as was allocated to you, to your departments, to provide this committee with a written response. Yet you didn't provide it, and they did. Why didn't you give this committee a written submission?
Well, so, Senator, sometimes we do provide written submissions to committees, but by and large, we're happy to present ourselves for questioning and provide evidence in this format.
Well, I appreciate that, and we know that you do that, but we do work off submissions. An opening statement that was provided today with a timeline is not an adequate response to the 15 submissions that come in. We're still operating out of a model where we haven't even had the government's response to the full report, which was a report from which there was considerable dissent, and a dissenting report provided by the Labor Party. Is this government just going to ignore all of the incoming, telling them this bill's a dog and they've got to get rid of it? Well, your writing instructions don't respond in writing. Did you receive an instruction to respond or an instruction not to respond? Or did you just not do it?
So, Senator, our standard practice is that for hearings, we attend hearings, but our standard practice in the past, as far as I'm aware, hasn't been to provide submissions.
Well, that raises a whole lot of questions about the level of respect for the processes of the Senate. if you can keep the Attorney General and the Treasurer happy, that's good enough for you. Well, the reality is the Senate wants to know what's going on, and the committees are supposed to be served by the departments. Mr. Smerdel, were you directed to not provide a written submission?
There was no direction, Senator. And in terms of how the department approaches submissions to committee and legislation inquiries, there's probably not a standard way of going about things, but it's often the case if a bill, the department, and in this case Working Treasury, is involved in preparing the bill and preparing all the extrinsic materials as well, second reading speech and the explanatory memorandum and the regulation impact statement. So there's already a wealth of material that departments put into preparing bills for passage through the Parliament, and we hadn't prepared a submission for the Parliamentary Joint Commission committee inquiry either, and in the time frame I think we had from swinging from the Parliamentary Joint Committee to this one, that we took the decision that what the materials already presented and the evidence we've already provided to the Parliamentary Joint Committee should be sufficient, but I'm hearing loud and clear your message to officials at this time.
Well, the government sets these timelines. You know, if the government doesn't give you enough resources to do your job, then, you know, that's worth fighting for, because the Australian people deserve a better response. This is a very complex piece of legislation. The government set an incredibly ridiculous timeline. We're all working to it. It really appalls me that this is considered an annoyance rather than a critical part of the development of good legislation, because that's what we're here to do, to make sure that we have good legislation that is in the interests of the Australian people, rather than give the government a free rein to just shove on through whatever they think, even if it's not constitutional. Like, this is really, really important work that we are doing, and I think it deserves a response. If 15 less resourced agents of the civil society of Australia can put in their submission on this appalling timeline set by the government, with all the resources of the department, I cannot believe that you haven't put in a submission. And I'm also going to reiterate, and I'll go to you, Chair, thank you, after this, my great concern about the fact that we haven't had a response to the constitutionality question. And further, can I make the point that you've just referred to your work on a regulatory impact statement? Can I remind you that there is no regulatory impact statement for this bill? The government relied on its own government-controlled Parliamentary Joint Committee for Corporations and Financial Services report that was hastily convened. They ignored the dissenting report. That is not an independent report. Any claim that that report is independent is a lie. And yet that report that has not had a response from the government, that was a dissenting report by Labor senators, is now being claimed by the government as sufficient to replace a regulatory impact statement and is being claimed as independent. Now, I'm sure you can understand, as professionals in the service of the public at the highest levels that you are, that what's going on here in this committee and with this failure to provide the constitutional basis for this legislation, rushing it through, the disrespect for the Senate, the failure to acknowledge that the PII claim was dismissed by another committee, all smacks of an incredibly rushed and improper process by this government to deny Australians justice. So I express considerable concern about the practices that you are operating with under the government with regard to this particular piece of legislation. With no disrespect to you as individuals professionally, you know, maybe you're just a casualty in the way that the government's choosing to run this, but it's not up to standard. It doesn't give us confidence that this legislation is constitutional and it will not have profoundly negative impacts on the Australian community and their access to justice. And I won't ask you for a comment on that because I know it's about your opinion, but I express severe concern, and I thank you, Chair.
Thank you, Senator O'Neill. And I should just tidy up. I think, Dr. Smerdel, you weren't implying that there was a regulatory impact statement undertaken with respect to this legislation. You were just making a general point around the usual practice the Attorney General's Department takes in terms of deciding whether or not to make a submission on any bill. And one of those factors you consider is the fact the bill's being prepared, the explanatory memorandum's being prepared, and there may be a regulatory impact statement, although
there wasn't.
There wasn't in this case for in Senator O'Neill's canvass those issues. Is that correct? That was the point you're making?
Thank you for clarifying, Chair. Yes, that's precisely the point I was making.
Yeah, and I should also note that, and just to reiterate for the record, and sorry to belabor this point, Senator O'Neill, but in terms of your opening statement, and I'll make it clear that you did make this clear in your opening statement, on 29 November 2021, the Parliamentary Joint Committee on Corporations and Financial Services Committee Chair, the Honourable Tony Smith MP, wrote to the Attorney General advising the committee did not accept the Attorney General's claim of public interest immunity on advice from the clerk. However, the committee noted it did not intend to press the claim. And that's, Dr. Smirtle, that's an accurate representation from the Attorney General Department perspective. Is that correct?
That's correct.
Okay, thank you. Senator Patrick, you have the call.
Yeah, thank you very much. So my questions are directed to Dr. Smirtle, and I don't want to engage in a confrontational discussion. I understand you are you've taken on notice what the heads of power are, but you are predicting, not unreasonably, that the attorney is likely to advance a public interest immunity claim in relation to the answering of those questions. I think it's fair, isn't it?
Thank you, Senator. I guess I'm not in the business of predicting what the attorney is going to do, but clearly the Parliamentary Joint Committee didn't agree with the claim, but didn't seek to press their rejection of the claim. So that's clearly something I'm sure the attorney will bear in mind in considering.
Sure. Because I just want to point out to you, and this goes to the treatment of the committee versus perhaps me as a person seeking that same advice under FOI. I'll just go to the Information Commissioner's guidelines, and I know you know of these. Paragraph 5150 of those guidelines state the following. Agencies are advised not to claim exemptions for a document under Section 42, which is a legal professional privilege claim, unless it is considered that real harm would result from releasing the document. Okay, that's the policy adopted in relation to FOI. Now, I just want to be very clear. In the FOI domain, the refusal under Section 42 is supposed to be only on the basis that harm results from the disclosure. And the origin of that is in fact your own department, and you might, I don't know how long you've been around, Dr. Smirtle, but there was a Secretary Brazil, and on the, I'll just get the date for you, on the 2nd of March 1986, the Brazil direction was issued from Cabinet, basically stating that principle.
Brazil,
is it?
Brazil.
Okay, thank you very much. It's spelled Brazil, so Brazil. So that's been a principle. I mean, you said at the opening, your opening remarks, that it's long-standing practice. I'm just trying to understand what the long-standing practice is, whether it's just an outright refusal, and we can talk about that, or alternatively, the approach you're taking with this committee is also centred on harm by releasing the document.
Thanks, Senator. And just looking at the attorney's letter to the committee, she was talking more about in terms of long-standing practice, quoting from Senator the Honourable Gareth Evans, Senator the Honourable Joe Ludwig, then Attorney General the Honourable Philip Ruddock. So it's really in terms of the practice of legal advice. But I think also I could add, which isn't in the Attorney General's public interest immunity claim, but because the committee is running a bit late, I had the opportunity to listen a bit to Mr. Emery's evidence as well, and he predicted that it would be inevitable almost that the government's legislation would be subject to legal challenge based on constitutional grounds, mainly from his evidence. So clearly, I think the fact that any disclosure of the Commonwealth's legal advice could prejudice the Commonwealth's legal position in relation to future legal action, and really, it's.
But isn't it true to say that that so too would not passing this bill in circumstances where there was legal question? So I'm saying there's harm to the taxpayer if you end up running litigation which fails the constitutional test. That we're, in some sense, we're talking about, I mean, if proceedings were brought against the Commonwealth, your position would have to be made available in submissions to a court. This is a preventative measure rather than one of saying the harm. There's harm that will flow if there's litigation at the other end, but the reality is we can avoid that harm by simply making sure that we're satisfied that the bill is constitutional. Would you accept that proposition?
I understand where you're coming from, Senator Patrick, but I don't think it's necessarily a bar to litigation occurring that that the government or the Parliament accepts that any particular legislation is constitutional. There's still private actors involved, and litigation occurs. And I think in this context, Mr. Emmerig's advice was pretty persuasive. I think that litigation will inevitably.
So I was just reading from Egan and Chadwick. You'd probably know that the Court of Appeal in the New South Wales Supreme Court, or Court of Appeal, the justification for legal professional privilege. This is a judgment, so this is law in Australia, not Rex's views. The justification for legal professional privilege does not apply when a House of Parliament seeks the production of executive documents. It must have the power to call for information relevant to the fundamentally important task of reviewing, changing, and adding to the statute law of the state. There will be from time to time information in executive documents either necessary or useful for carrying out that task. Do you accept that principle? And this is just to put this into context. This is a legal ruling in New South Wales related to the Legislative Council. You might recall the Egan controversy there, where the courts made it very clear that legal professional privilege is not something that can fetter, not something that is not within the power of the Parliament to order.
Sorry, can you just run that quote by me again, please, Senator?
Okay. Well, I'll read two of them to you. This is from Justice Spiegelman, Chief Justice, and Justice Mager. In performing its accountability function, the Legislative Council may require access to legal advice on the basis upon which the executive acted or purported to act. Access to such advice may be relevant in order to make an informed assessment of the justification for the executive decision. Accordingly, access to legal advice is reasonably necessary for the exercise by the Legislative Council of its functions. It then goes on to say, what, if any, access should occur is a matter of the occasion and of the manner of the exercise of a power, not of its existence. It basically, and that's quoting the High Court, well, that's referring back to the High Court in Egan and Willis. The other justice, so all three justices agreed on this point on legal professional privilege. Justice Priestley says the justification for legal professional privilege does not apply when a House of Parliament seeks the production of executive documents. It must have the power to call for information relevant to the fundamentally important task of reviewing, changing, and adding to the statute law of the state. There will be, from time to time, information in executive documents either necessary or useful for carrying out its tasks. So, you can have all these attorney generals say what they like. They don't make law. The parliaments do, and it is the courts that then properly interpret that law and perhaps give clarity to it. it's on that basis that, and perhaps I would ask you to inform the attorney in her consideration of this, what the legal position is, and one would hope she will uphold the laws of this land, accepting the power of the Senate to order these documents. And look, and I say this: is it helpful to you that rather than being a request from a single senator, that the committee actually orders production of the documents, and that it compels the provision that may give greater protection in terms of not waiving privilege elsewhere?
Just in relation to your last point, Senator, the Parliamentary Joint Committee did order production of the documents, and that's when the attorney made a public interest immunity claim. So, I mean, yes, I hear what you're saying, and that's some of the, I mean, it's probably not necessarily a legal proposition when it's the Senate committee testing the public interest immunity claim as distinct from a claim of legal professional privilege in the courts, which is tested by the courts.
So now, just to be clear, that particular matter was whether or not it was proper. So it was brought on by Mr. Egan, who was required to provide documents to the Legislative Council, and took the matter to court. And so the matter was not about whether privilege applied in the proceedings themselves. The question being asked by the court was, did the Legislative Council of New South Wales have the power to seek documents that were subject to legal professional privilege? And the answer from the court was yes, it does. And it basically went on to say, and by the way, privilege is not actually waived, because whatever you table can still not be used in a court of law because it's protected by parliamentary privilege. So there's no harm in the context that legal professional privilege has one aim and one aim alone, and that is protect the confidentiality of client-lawyer relationships in respect of what can be disclosed in a court. Of course, you have to keep it confidential everywhere such that you don't waive the privilege, but the protection still applies in circumstances if you are compelled to make disclosure here, because it simply can't be used in legal proceedings.
Yes, sorry, Senator. I had understood that you meant the court was ruling on the ability of counsel in relation to legal professional privilege. There's probably not much more we can add in this exchange. In that I've certainly heard the committee's views in relation to the.
I'm just trying to be helpful in what you might provide also to the attorney in the making of her or in her consideration of the claim before this committee. One is I'm pointing to the advice in Egan and Chadwick and others. Citation is ALD 30102/98. And also just giving the additional advice, I'm absolutely going to put in a second reading amendment that suggests this bill has to go back to committee until this question is resolved. I think it's absolutely unreasonable for the government to ask the Senate to pass a bill when it can't state what the head of power is. That's just outrageous. Do you think that's not an unreasonable position for us to take?
That might be asking Dr. Smerdel an opinion, Senator Patrick, but I'll let him answer to the extent he wants to.
Sure.
I think Senator Scarr put the words into the chair, put the words into my mouth. Thank you, Chair. But we've heard the committee's points, and I've taken them on notice, and we'll take it up with the attorney.
All right. Thank you very much. I'll get on to the drafters now about my second reader. Thank you.
Okay, good. I'm sure they're on the edge of their seats waiting for that, Senator Patrick. Dr. Smerdel, can I ask you a few, or it might be you, Mr. Dixon, or Mr. Bowd, who's managed to escape our attention today. I wanted to ask a few particular questions in relation to the content of the bill. We've talked about constitutionality, we've talked about process. The explanatory statement itself, and I want to try and keep this at some sort of a high level. The explanatory memorandum, the second dot point under a number of the key impacts identified from the bill are listed below. The second dot point is litigation funders may be incentivised to undertake greater book building to inform their decision to support a class action, which entails identifying, communicating with and enrolling class members to the action. End quote. So that's on page 4 of the explanatory memorandum. And it seems to me that key impact is linked to the question of open class actions and closed class actions and common fund orders. So I'm wondering if it's possible for either you, Mr. Dixon or Dr. Smerdel, to provide and there's been a lot of commentary in relation to opt-in, opt-out, the benefits of both. But I'm interested to know, what is the actual intention of the legislation with respect to this issue of open class actions, closed class actions, opt-in, opt-out, common fund orders? Is the bill seeking to bring about a set of circumstances to encourage this actual book building? Is that the intention behind the provisions around common fund orders, etc.? Because there's a lot of commentary at the moment in relation to that and the impact it might have. So it'd be useful from my context to really understand the intention in that regard. So who would like to address that issue first?
I think my Attorney General colleague might be the best placed for that one.
Looking at that they take the question, but sorry, am I?
Yeah, Dr. Smerdel, are you? What's the intention behind the? And there's a policy issue there, but in terms of the intention in the drafting of the bill, what is it seeking to achieve in terms of this issue of opt-in, opt-out, common fund orders, etc.? Is it because we've heard some evidence that it could lead to people moving away from open class action? So I guess the first question is that the intention, or is that something which people are looking beyond the black letter drafting of this bill in terms of the potential consequences as they foresee it? What's the actual intention?
Thanks, Chair. And some of those actually probably end up being commercial decisions undertaken by the litigation funder. But the intention really is, and that's probably why I hesitated, because it all comes back, I guess, to, and where the Treasury would answer first, but it all comes back down to the actual intention of the bill being to provide more fair and reasonable returns to class action claimants, the members of the class. So there's a framework that's being put in place there now through the legislation, which attempts to deal with that. And so the primary concern about open class actions is, coupled with common fund orders, is that they can be used in a way that I guess would be seen as getting people to provide legal litigation funders commission rates when they actually haven't signed up to any deal. It's a privity of contract kind of arrangement, that there is no arrangement in place in an open class action for those that are just sort of sitting on the sidelines and not potentially even knowing that the class action is underway, that they are bound in an open class action to provide the full funding commission rate to the litigation funder, as well as the legal fees, which is fine. So that's why the framework has been put in place. And the High Court itself, I guess, in the BMW and Brewster case, expressed some concerns about common fund orders in that same context, in that there is no legal relationship in law and equity between the litigation funder and unfunded class members who have not agreed to be part of the litigation funding claim. So in terms of whether open class actions are still allowed, yes, they are, because that's still governed by the court's own legislation. So there's nothing in the bill that prevents an open class action from occurring. And in fact, the bill contemplates that because it, in various parts, acknowledges that there might be other members to the class other than those that are part of the managed investment scheme, litigation funding managed investment scheme. So the High Court spoke favourably about funding equalisation orders, which differ from common fund orders in that funding equalisation orders mean that it's the actual costs distributed between those in the funded members that are part of the litigation funding scheme and those unfunded members. And so, as I said, the High Court plurality spoke favourably about that because the actual costs mean that the all the legal costs and the costs, the commission costs that would be contributed by the funded class action members are then distributed across pro rata way across the entire class. So that means that there's an even distribution across the entire class. So that's how funding equalisation orders work, as distinct from common fund orders where the legal costs are shared across, but the funding commission is then multiplied out across the entire class as well. And that's probably where the legal concern arose from in the High Court matter.
Okay, so there is an issue. So I guess 2 points flowing from that in terms of the following question. Put this bill to one aside. There is this uncertainty in relation to common funding orders generally. The matter has been considered by the High Court in that Brewster case, but there is a general issue with respect to certainty about what does that mean going forward in terms of common fund orders. Is that a fair comment?
That's a fair comment, Chair. So the bill takes no position on common fund orders. It doesn't legislate to say that they exist. It just sort of notes that they're about, but they're still a court construct. What the High Court did decide was that common fund orders can't be used at an early stage of the proceedings, which I guess is desirable for litigation funders because it opens up the prospect that you can commence an open class action and then get a common fund order at a fairly early stage of the proceedings, which gives the litigation funder a bit more certainty of outcomes. But the High Court in the Brewster case said that it can't occur in the early stage of proceedings. So then it's open as to what is the position in relation to a common fund order at a later stage of proceedings, whether at settlement stage or at a final order stage. And so I think some in the federal court have taken the view that they can be done, but until it gets to the High Court again, then there is still that level of uncertainty in relation to common fund orders. But the government's concern with common fund orders is, because it basically comes down to increasing returns to the claimants in the litigation funding matter, so that common fund orders disproportionately can magnify the returns to litigation funders because the funding commission rate gets multiplied out across the entire class, those that are funded and those that are unfunded. And so that's the concern, to try and bring more high returns to claimants. And so in that context, the provisions put in by the bill, plus if the courts use funding equalisation orders in an open class action, then the government would see that would be a good way forward. But ultimately it's a decision for the litigation funder because the returns are likely, as the PJC, Parliamentary Joint Committee, found, the returns from funding equalisation order are probably not going to be as high for a litigation funder as what they would be under a common fund order.
Okay, so is it fair to summarise the point by saying that the legislative scheme contained in the bill should have the impact, or is expected to have the impact, of promoting more funding equalisation orders as opposed to common fund orders? Is that a fair assessment?
Commercial decision at the end of the day for the litigation funder and the lawyers, I guess, in that there is nothing in the bill that prevents common fund orders, but if you want the certainty, the legal certainty of the framework provided by the bill, then a court can't provide a common fund order. But so there's nothing in the bill that says, it probably sets the intention that a bit more book building be done to test the veracity of the claim, to test the interest of the class, to see how many people you can come in and join the class. But there is still the ability there for an action to be in an open class and for a court to apply a funding equalisation order, which would be within the terms of the bill. If a court applied a common fund order, then they would lose the protections of the bill. And given the uncertainty of common fund orders, then that's a commercial decision that would need to be made by the litigation funder.
Okay, thank you. There has been some evidence given earlier today with respect to what extent the recommendations of the Australian Law Reform Commission have been adopted or not adopted in relation to its report on class action litigation funding. What's the position from your perspective? Does the bill implement some of the recommendations from the Australian Law Reform Commission and not others, or to what extent is the bill consistent or inconsistent with the Australian Law Reform Commission's recommendations?
I'd probably need to take some of that on notice because I've been fairly late to joining this particular reform exercise. But what I can say is that this was really just a priority tranche of legislation that the government undertook in response, and my colleague from Treasury will probably be able to expand on that, but a priority tranche of legislation to deal with the issue of what was seen as excessive returns to litigation funders and to try and ensure reasonable and fair returns to the claimants in a class action proceedings. But so the government has responded to both the ALRC and the Parliamentary Joint Committee reports, and so some of those things will still be under consideration. But in terms of working through each of the recommendations, I'd have to take that on notice, Chair.
Yeah, if you could take that on notice, and I think it would be useful for us to have, given the evidence that was given earlier today, it would be useful for something to be on the record in that regard from the perspective of the Attorney General's Department. I'm alive to the fact that we've been going for some time. There was one question that was raised in the Law Council of Australia's submission, which I was interested to get your view on, and I'll quote from paragraph 42 of the Law Council of Australia submission. Proposed paragraph 601 GA2B states that the court may only approve or vary a claim proceeds distribution method if, quote, the proceedings are sufficiently progressed to enable the court to determine whether that claims proceeds distribution method or any variation of that method is fair and reasonable, end quote. The practical effect of this paragraph may be that a court is unable to approve a settlement in the early stages of a dispute, despite this being in the interests of the group members and defendants alike, end quote. So clearly, from the perspective of, from a policy perspective, I guess there are two competing interests here, but one is the interest in having litigation disputes resolved as early as possible prior to additional costs being incurred or time being taken, so all of the stakeholders have the benefit of a resolution as quickly as possible. Particularly, I would have thought in circumstances where the parties have come to an agreement through mediation. What's the policy intention of that drafting in terms of how it would work in practice? What's the concern, the mischief, if you like, that arises out of the proceedings not being, and the phrase used is sufficiently progressed? What would that potentially mean in practice? And I guess just why it appears you might be looking for an additional document, Dr. Smerdel, but from my perspective, it conjures up, the concern raised by the Law Council of Australia conjures up a circumstance where the plaintiff, the defendant have each come to an agreement. They go to court, and the concern is that the court said, well, proceedings aren't sufficiently progressed to enable us to determine that the claims proceeds distribution method or any variation is fair and reasonable. So we can't sign off on the settlement, so the action has to proceed, notwithstanding the view that the parties want to come to a mediated settlement, which I suspect is not the intention.
Can I check with my colleague from Treasury whether that's one from Treasury to take?
So, Senator, for that one, we might take that one on notice. But I mean, obviously, the intent is to make sure that there's good decision making through this process. Question arises as to the likelihood of whether somebody would find themselves having gone through mediation, reached agreement through that process, and then was denied by the court. But I'd like to take that on notice if I could.
Yeah, if you could, Mr. Dixon, because I guess from my perspective, there's a question of whether or not there's an unintended consequence in terms of how the provision's drafted, and it may not be the intent underlying the provision. The provision may be seeking to achieve another outcome. But if I can encourage you to refer to sections 42 and 43 of the Law Council of Australia's submission, that would be very useful from my perspective. And Dr. Smerdel, and you might not be able to answer this given the issues around constitutionality that have been well and truly canvassed, and thank you for your patience during that discussion. It's greatly appreciated. Section 55 of the Law Council of Australia submission discusses, and I quote, "Furthermore, insofar as there is an inconsistency between the proposed provisions and provisions of the FCA Act, there may also be an implied repeal of those FCA Act provisions. These are matters of particular significance." Now, I don't want to take you into areas where you can't go, and you might need to take this on notice, but it begs the question in my mind as to whether or not that's the intention in any event of the legislation, that is the intention to actually repeal any part of the FCA Act by implication.
Thank you, Chair. I mean, certainly his intention to modify the application of how the federal court goes about things, but whether there's an intention to repeal, I think it is better to take that one on notice. Thanks, Chair.
Yeah, no, I'm quite happy for you to do that, because it does beg the question from my, and the reason I ask is, well, if that's the intention, maybe that should be clear, but is that really the intention? So if you could take that on notice, I think that would be very useful. I might just ask my colleagues if they've got any further questions, because I think I'm done, and we do appreciate that we have gone over time. So are there any other questions from any colleagues?
Can I indicate that there'll be a number on notice? I'm just mindful of the time, Chair.
Okay, thank you, Senator O'Neill. Senator Patrick?
I'll just indicate that I've lodged my second reading amendment to be drafted, so it's on its way.
All in real time. It's quite exciting, Senator Patrick. Thank you.
It is. Thank you.
Thank you very much. And Senator Chisholm, if you've got any additional questions, now's the time. No? Okay, thank you. So that then concludes today's hearing. On behalf of the committee, I would like to thank all those who have made submissions and sent representatives here today for their cooperation in this inquiry. And Dr. Smerdel, thank you very much for the professional way in which you've answered the questions. And Mr. Dixon, thank you as well. It is greatly appreciated. I remind all witnesses that answers to any questions on notice are due by 24 January 2022. And we appreciate it's an aggressive timetable and greatly appreciate your endeavours in terms of meeting that time frame, given the date by which this committee needs to report. And on that basis, the committee now stands adjourned. Thank you very much.
Thank you,
Chair. Thanks all.